Good
Yes.
morning, all. This hearing is in the matter of CFI 051-2017 before His Excellency Justice Shamlan Al-Sawalehi. The claimant is represented by Clyde & Co. LLP. Lead counsel is Mr. Tom Montague Smith, KC. The defendant is represented by Al-Tamimi and Company, and lead counsel is Mr. Timothy Killen. Thank you, Your Excellency.
Thank you. Right, this is the appeal from the defendant. So just,
Oh, not quite.
I'm sorry. Yes.
This is the quantum hearing.
Yeah, the quantum hearing.
The
Yes.
appeal is in a couple of weeks' time, I think.
Yeah. Sorry. Yes, I got
Not
that.
at all. Not at all. So I'm here for the claimant, and my learned friend, Mr. Killen, as you've heard, is here for the defendant.
Yeah.
We've had a discussion about the timetable, and I think it's agreed I will go first. My learned friend will respond, and then there'll be time for a short reply if necessary. I'm hoping to get through what I have to say in about 2 hours, but I will try and be briefer if I can. My learned friend will then have, if he needs it, 2.5 hours, and there's half an hour for reply if needed. So we think that is plenty of time. I think that is plenty of time, and we'll try and move through it as fast as we can. We don't have any transcribers today, so we are in your hands as to when and whether we take breaks.
Yeah.
We have tentatively assumed you will take a break after my submissions, but we can do it as you prefer, Your Excellency.
Well, we'll take a break at 1 o'clock if that's fine, Dubai time, and then we'll take it from there. We'll see how it goes. Yes, go ahead.
Good. Thank you. All right. So, as you know, we are here to deal with the remaining outstanding issues on quantum between the parties, and those have emerged and crystallized in discussions between the parties about where you get to on quantum. And the experts have put their mind to that, and they have put together a joint schedule, and that illustrates the issues. And I think both parties make it 7 issues ultimately that need to be decided. Some very short, some slightly more substantial. If you can decide those 7 issues, I am confident. I haven't asked my learned friend, but I assume he would be confident that the experts would be able to reach a number if you decide that some of the issues go one way and some of the issues go another way. We have some numbers for you, but obviously those assume that certain of the issues are decided in particular ways. And so it's not impossible that you would find a conclusion that is somewhere between those two. But hopefully we have isolated everything that is really of controversy that remains. Now, for the claimant, we've sought to summarise what we say about those issues in our written submissions, and I hope that Your Excellencies had a chance to have a look through that. Your Excellency's decision in January resolved most of the issues, but there are obviously a few areas remaining of disagreement. Now, just to preface, I mean, the main issue, the most substantial issue between the party, or the 2 most substantial, are what have been referred to as ramp up and ramp down. And that's the sort of period over which lives, if you recall, would be transferred, firstly from the insurer to the TPA, from the defendant to the claimant, and then at the end of the contract, back again from the claimant back to the defendant. And of those 2, I think it's fair to say that ramp down has the most substantial effect on quantum. But there are a number of other discrete issues, and I'll provide you with a shopping list, if I may, of those points so that we can go through them. As I say, the parties have presented the calculations on the basis of their positions, and you may find a slightly different way through. What I proposed to do was show you the schedule and how the issues arise in that schedule. And then after I've done that, go through each of the issues and tell you what I say about them. So if you have the bundle and can go to tab D8 and page 1131 of the bundle. I don't know if you need the tab numbers, but if page numbers are sufficient, then I'll just give you page numbers. It's page 1131, so you'll see the schedule of differences. And I'll just, if I may, just try and help you orient your way through that document. you will go, if you go through to page 1134, you'll see where the experts start to discuss the central areas of difference. You see that at paragraph 1.7. And so you've got the issues in the table, principal areas of difference. What the experts are doing here is identifying what they see as the most impactful, the most significant in terms of quantum. So you've got, firstly, the duration of ramp up. That's the time it will take for the transfer of lives to the claimant. And I'll explain a little bit more about these in a moment. Then over the page, you see issue 2, the duration of the ramp down period. So that's the time over which and the period when lives would be transferred back from the defendant to the claimant at the end of the contract. Number 3 is a discrete issue about how many lives could be managed by the existing claimant's staff. So this is about the point at which they need to take on more staff to manage a particular number of lives. There's a discrete issue about that. And then the 4th one there you will see is the profile over which staff would be terminated once the agreement has ended. So that is the reason why ramp down is so significant is because if there is a longer ramp down period, the claimant is carrying cost for a longer period. And one of the main elements of that cost is staffing costs. And so the period, the profile over which staff would be terminated turns primarily, we would say, on whether there is a ramp down period, and if there is, how long it is. But secondly, my learned friend has a couple of other points about termination of staff. He said they'd need notice and things like that, but I'll come to those. We say it really follows from the ramp down. So those are the most impactful issues, not all of the issues. But what I was going to do was just take you through the structure of the quantum calculation so you can see where they slot in and how they affect things. So if we go forward to page 1137.
Yes.
What we've got here is the structure of the claim, setting out firstly the revenue that would have been obtained from the OIC side of things, then the costs in a line-by-line way. You've seen a schedule quite similar to this previously, and there were competing schedules previously. What this schedule does is it feeds in your decisions and then identifies the areas of difference that are remaining. So the first 2 rows of this dealing first with section A, which is the OIC claim. I'll come on to the non-OIC claim later. Section A of this, then dealing with the OIC claim, rows 1 and 2 are not calculations in and of themselves. Those just explain the parties' approaches to ramp up, firstly, number 1, and then over a few pages, I'm afraid you have to go all the way down to page 1141, ramp down, and then they're explaining what assumptions they've taken in their calculations. And then if you keep going down, you'll see at 1144,
yes,
on row 3 is the runoff period. So that it's important to be clear about this, that the ramp down is not the same thing as runoff. So just dealing with those 3 concepts and keeping them separate. Ramp up, as I say, is about how quickly the OIC portfolio of lives would be transferred to the claimant at the start of the contract. Ramp down is about when those lives would be handed back after termination or at termination. So we say that question is about whether after termination Globemed would have continued to manage lives, and if so, whether you should take that into account in assessing damages, and I'll explain that in a moment. Because we say effectively Globemed had no obligation after termination to manage any lives. What it had, which is different, is runoff. Runoff is about existing claims at the date of termination. And Globemed was obliged to deal with claims, but that is separate and different from managing the lives and providing all of the full services that are associated with that. And that's important because the costs associated with managing just a bunch of claims is very significantly different from the cost associated with managing the lives overall. So existing claims would need to be managed by Globemed because that's in the contract, and the parties are broadly agreed about the impact of that. There's no real controversy that anyone's going to tell you about in relation to run off. But as I say, that's not the same thing as ramp down, which is about handing back lives. All right, and then just to put you back into the structure, if your Excellency looks back at the schedule, you'll see row 4 is then about the income that would be generated as a result of those prior assumptions, and that's affected by the ramp up period. But there's no difference between us as to how it's affected. So once you've made a decision on ramp up, we can calculate the administration fees. Because the reason it's affected by ramp up is that the sooner the claimant gets lives on board, the more lives there are at the end of the first year, and then the more fees that they earn in that year and going forwards. So if you look at those columns, on this basis, it looks like the effect of ramp up is quite significant because you've got a difference between the claimant's best case of 124 million and the defendant's scenario CB1 of 114 million. So if you took this in isolation, you'd think that ramp up had a 10 million dirham difference to the claim, but it's actually its impact on quantum is much less significant than that. It's much more limited than that because there's also a cost associated with a faster ramp up. So faster ramp up means more lives sooner, which means more staff sooner, more premises sooner, more other costs sooner. So the profit associated with a faster ramp up is less than actually just purely the difference between the administration fee. So it's not insignificant, but it's not by any means as significant as ramp down, because ramp down, there are no fees associated with that period at all. So if I'm right that there was no obligation to ramp down, to manage lives after termination, then I say there would be zero cost after that, whereas my learned friend has a year of cost after that time to deal with handing back lives gradually. Just back to the schedule then, just to complete the picture, you've got, and we're still in costs. Sorry, we're still in revenue, but row 5 is volume rebates. And one of the consequences of your Excellency's decision on the volume rebate rates in the judgment was that there are going to be no volume rebates at all. Nothing was earned at all would have been earned at all in relation to that. So that's the revenue side of the OIC claim, and then we go on to costs, which are the subject of the next rows in the schedule. And there is the cost of cards. These are the cards that were issued to the individuals, and there is a small difference between the parties in relation to that, but that flows entirely, I think, from ramp up. And then you've got row 7, which is payroll. And this is an area where there is quite a substantial difference. And actually, the scale of the difference here resulting from ramp down is slightly masked because the two main issues pull in different directions. So earlier ramp up increases costs, but increases revenue by slightly more. Later ramp down increases costs very substantially. So, as I say, the defendant's model has Globemed supporting the provision of services for a year after termination. That comes at quite considerable cost, but the defendant doesn't suggest that Globemed would be paid for that. There is another, in relation to payroll, there is another discrete point, and I'll come on to this. Effectively, as I understand it, the defendant makes some points about saying, well, it would be unrealistic suddenly to terminate everyone the day after termination. And my learned friend makes points like there would be notice periods in contracts. I will deal with those discrete points as well. We say there's nothing in that sort of thing because Globemed would have a year of notice of the termination. so it can manage giving notice to terminate staff quite easily. There is another discrete point here in relation to the payroll costs, and that is it's about the number of lives which could be managed, as I mentioned, by the claimant with its existing staffing levels. And what is said is that Mr. Cottle, for the claimant, has changed his mind about something. We say it isn't that at all. It's absolutely clear from the evidence, and it's been explained. His approach is effectively being mischaracterized by the defendant, by Mr. Burrows. I'll explain that to you when we get to it. But that goes to staffing costs.
Yes.
We then get all the way down to page 1149, which is rent. This follows from ramp up and ramp down. And effectively more staff means higher costs of this. So there's no discrete issue to be decided in relation to this. And similarly with depreciation, that will flow from the other issues that arise, and similarly with general costs as well. So once you've decided all the other issues, then these will be capable of calculation fairly straightforwardly. There is a discrete issue in relation to ASP hosting fees. So there were fees which would have been payable by the claimant to another Globemed entity for ASP hosting fees, which is essentially the technology used to host the management of lives. There is a discrete issue between the parties. The main difference between the numbers is about it flows from ramp down, because longer ramp down means that the claimant's hosting more lives for longer, so they're paying more fees for these services. However, there's also a new point raised by the defendants about whether or not in runoff fees accumulated when no lives were being hosted. So runoff is the period, as I say, when there's no lives being hosted, but there are claims being managed down. That depends, in part, on your interpretation of the agreement under which these fees arise. So I'll have to show you the relevant section of that agreement, which is the franchising and licensing agreement, and you'll take a view on that. According to my learned friend, that contract requires fees to be paid even when there are no lives being managed, so even when there are no services of that sort being used. Row 12, if we go over the page, 1150 is royalties. That is simply a proportion, a function of the fee income, which depends on ramp up. So there's no discrete issue there. Actual costs, you will see paragraph row 13 are agreed. There is then interest. Now we say rather startlingly, the defendant says there should be no interest that should run since January. Quite why is difficult to follow, we say. My own friend says, well, there's a delay since the judgment to today, and that is caused, my own friend says, entirely by the claimant taking a particular position on these issues for this hearing. That, he says, has delayed judgment. Quite why that should stop interest running is not really explained, but there we are. My own friend says, well, for the same reasons there should be no judgment rate interest. We say that's all pretty baffling. Interest is for being kept out of your money, and the defendant has never paid a cent. So on your figures, the defendant now accepts that, subject to its appeal, it's liable for at least $8 million, $343,000 and so on, but it hasn't ever paid any money. So interest will and should continue to run until it actually makes a payment. Those are the points on the OIC claim. On the non-OIC claim, there is also a difference, and you'll find that on page 1151. That is simply a short issue of disagreement about what you mean in your findings, in your judgment, about how we calculate the non-OIC claim. The slight concern that we have in relation to this is that the defendant is trying to get you to characterize your finding as a loss of a chance decision, because that's the basis of its application for permission to appeal. That's how its permission is advanced. So we say it's not a loss of a chance approach. In fact, the parties are pulling in slightly opposite directions to their interests on this, because my way of calculating the non-OIC claim comes in at less than my learned friend's way of calculating the non-OIC claim. But I'll take you through that and what we say about that briefly. That'll be the last issue. So that's the shape of the calculation. The issues, as I say, which emerge from that are 7, and I'll give you a shopping list now if that's all right, and then we'll go through them. So the first issue is ramp up. The second issue is ramp down. We have this issue about staffing threshold, how many lives could be managed by the claimant's existing staffing. Issue 4 is the staffing reduction after the termination. Issue 5 is ASP hosting fees. Issue 6 is interest. Issue 7 is non-OIC claims. So that's the shape of it. And now what I was going to do, Your Excellency, with your permission, is go through those one by one and just tell you what I say about that. So ramp up is the first issue. And we say you've already decided this. And this really comes down to the interpretation of a paragraph of your judgment. So we read that as deciding when lives would have been transferred. So if I may show you that, it's on page 80 of the bundle. Sorry, it's on page 79 of the bundle. It's my mistake. And if we start at paragraph 85.
Yes.
We are saying, just to set the scene, what we say is you decided here that the lives would be transferred by 15th of January 2016. My learned friend says that's not what you were deciding, but we say it's pretty clear. So 85, just at the end, looking 3 lines up from the bottom, you say, just in case it would have an impact, I will attempt to identify a point in time at which it can be said that the transfer certainly would have happened. So you're dealing with the date of the transfer of Bupa's portfolio, and you are saying, this is the task that you've set yourself, paragraph 85. You are trying to identify a point in time when the transfer would have happened. And then paragraph 86, I won't read the whole thing to you. You recite some of the evidence, and then in the middle of the paragraph, you say, the complete portfolio, of course, included the Bupa portfolio. There is evidence before the court, therefore, that the parties understood that the Bupa portfolio would be transferred to GMG by 15th January 2016 at the latest. You then, if we skip down to 3 lines from the bottom, you say, if, however, the date of renewal for OIC's relevant contract with Bupa is ascertainable and was before 15 January 2016, then that is the date that shall be assumed for the transfer of the Bupa portfolio. So we say that's a decision about when the portfolio would have been transferred. That's our understanding of the paragraph. My learned friend's case is that actually what you were deciding here is just when would Bupa have consented, not when would the transfer have happened. Our short answer to that is that's not what the paragraph says. Paragraph 85, that section that I showed you, shows you that the whole point of the following paragraph, paragraph 86, was to ascertain when the transfer happened. And we can see that from the other parts that I showed you. And the final sentence, we say, makes it abundantly clear. The court was looking at when the transfer would have happened, because the court is saying, well, if there is another ascertainable time for the date of renewal of the contract with Bupa, then it's going to be, the transfer would be before the 15th of January 2016. So the whole context and the whole exercise that you are undertaking, we can see that in paragraph 86 is clearly, we say, about when transfer would have occurred. Now, my learned friend cites in his skeleton argument quite a lot of authority about finality. We don't really understand what point he is making in relation to that, but what is right is that clearly finality is important, and where the court has decided things, what we can't do is have a hearing like this and come back and say, look at the evidence. You may have decided this, but actually the evidence points in a different direction. Effectively, what we say my learned friend's trying to do is rewrite this bit of the judgment by having another go at it, and that is not, we say, permissible. My learned friend's second argument is that this passage is only dealing with Bupa, but it's dealing with Bupa specifically because that was the part of the portfolio that was likely to transfer last, because it needed Bupa consent. So we say the judgment read fairly is clearly dealing with the date of the transfer of the whole portfolio. And we see that from the passage that we've looked at. So you say in the middle of paragraph 86, the complete portfolio, of course, included the Bupa portfolio. And we say no one has previously seriously suggested that the rest of the portfolio would take longer to transfer than the Bupa portfolio. There'd be no basis for that. I mean, in theory, you could decide, or you could have decided, that the Bupa transferred by this date, 15th of January 2016, but then the rest of the portfolio would take longer to transfer. But that is not a commercial solution. It's not supported, and it's not a natural reading of your judgment. The result of that reading of your judgment would be that you dealt with Bupa, but you forgot to deal with the rest of the portfolio, and we don't think that that's terribly likely construction of your judgment. But that is the basis, as we understand it, for the defendant's alternative calculation. And so if that was your decision, then that calculation can be done, but we say that can't be right. I mean, ultimately, the contract required OIC to transfer the whole portfolio to Globemed. That obligation, we say, started as soon as the contract was concluded, and you had Mr. Salaba's evidence before the court that would have happened within a year. We can see that on page 121 of the bundle, paragraphs 88 of his evidence. My understanding that in circumstances where the parties understood the launch date to be 24 May 2015, OIC's complete portfolio would be transferred to GMGHS in the first contractual year, i.e. by 15 January 2016. So we see that actually your decision is consistent with the evidence, if that matters, but fundamentally you shouldn't be redeciding this. You should just be looking at what you've decided and applying that. So that's it on ramp up. It just turns on what you meant by those two paragraphs of your judgment. So I'm going to be, unless you've got any questions for me on any of these, and do interrupt if you do, I'm going to move on and say what I have to say about ramp down. Yes. As I said previously, that this issue is the most significant difference in terms of quantum between the parties. And we say on ramp down, the critical thing to realise is that there would have been, so we're assuming here the contract proceeded in accordance with its terms, there would have been no obligation on Globemed to manage lives after termination. So there's this obligation to run off claims in the run-off period, but there's no obligation to manage lives. And that, as I say, is significant because the costs associated with managing lives are much higher than the costs associated with running off claims. So the claimant's calculation is based on the assumption that the claimant would have stopped managing lives on termination. The defendant's calculation assumes that the claimant continues to manage lives for an entire year after termination. So on the defendant's calculation, the claimant provides services for 3 years. At the end of year 2, the defendant gives notice that it intends to terminate. The contract comes to an end at the end of year 3, and the claimant just carries on providing services for a year for free without being obliged to do so. That's what we say their case comes to. And that comes at huge cost to the claimant. essentially the difference between well, we say it's difficult to put an exact number on it, but we say that the difference in cost is something like $9 million. About half of the profit on the entire contract would, having been earned, simply be poured away on providing free services which the claimant had no obligation to provide. So we say you have to start with the terms of the contract, because it's the terms of the contract which matter. Why do we say that? Because, I mean, if we go right back to first principles, what Your Excellency is trying to do is assess the lost profit. So the job of assessing the lost profit is firstly understanding what the claimant would have earned by performing the contract, and then assessing the costs they would have incurred by performing the contract. So that's what we have to look at. What were the obligations? If we could go, please, to page 382 of the bundle. So this is we're now in the TPA agreement. And so this is the central contract between the parties, the only contract. Clause 2 is where you find Globemed's primary obligation to provide services. So you see there, for the purposes of this agreement, Globemed shall provide the following third-party medical claim administration services. And if you scroll up to the top of the page, you will see the term of the contract means the duration of this agreement and any renewal thereof as identified under Article 16. Termination is in fact dealt with on page, in clause 13 on page 393 of the bundle. So if you go forward to that, please.
Yes.
You're ahead of me.
Just put the number.
Yeah, sorry. So if we go to 392 defines the term, and you found that the term, we had you'll remember the long debate about whether or not the term meant that the contract lasted for 3 years or 4 years, and you have found that it lasted for 3 years. And then you've got clause 13, which deals with termination. And in particular, I'd ask you to look at clauses 13.3 to 13.5, and I'll just go through them with you. So the 13.3, the termination of this agreement is deemed ipso facto a termination of all the contracts and addendums to this agreement concluded between its parties. For the avoidance of doubt, termination shall enter into effect at the end of the notice period or non-renewal period. So that's it. That's a termination, complete termination of all of the parties' contracts. Obligations, rights are dependent on the existence of the contracts. So subject to the following terms, once the contract is terminated, all obligations cease. 13.4, upon termination of this agreement, Globemed shall provide the client with all maintained records. So there's a particular positive obligation to do something upon termination. And then clause 13.5, the effects of this agreement shall remain valid for a run-off period to serve the beneficiaries and healthcare programs issued prior to effective termination date until the settlement of all the pending claims. If this agreement was terminated, subject to 13.2, client's financial obligations and so forth shall survive. So what you've got is there the run-off period. The effects of this agreement shall remain valid for a run-off period to serve the beneficiaries and healthcare programs issued prior to effective termination date and until the settlement of all the pending claims. That is the run-off period. So the obligation, the primary obligation that you saw in clause 2 to manage lives ends on termination, subject to the run-off period. So there's an obligation to provide services for run-off purposes, but that is limited to running off claims. And that is a separate element which the experts have agreed the consequences of. So the issue between the parties is not about runoff. It's not about the financial consequences of runoff. The issue between the parties is whether, despite termination, there was a need or an obligation on the claimant to continue to provide the management of lives for a year while lives would have been handed back gradually, according to the defendant, from the claimant to the defendant over that period. We say there's no obligation in the contract on the claimant to do that. Now, obviously, the parties could have reached an agreement that the claimant would have done that and would have managed lives after termination, but those would have been additional services not covered by the obligations in the contract. And if you go back, please, to page 383, you will see that that clause expressly contemplates additional chargeable services. You see that at the top of the heading of clause 3. And there's some particular types of services that are anticipated, and then 3.6 other services as mutually agreed. So if the insurer had wanted the lives to come back gradually over the course of a year, which year was to be after termination, then that could have been agreed, but there would have obviously been fees associated with that. I mean, effectively what that does is it adds another year to the contract, and so you come closer to the 4-year calculation that we presented in the first place. But the defendant's case is that despite this contractual setup, despite not having to do anything of this sort for a year after termination, Globemed would have provided those services, would have provided them at huge cost, and would have provided them for free. So we say that cannot be a fair way of approaching the assessment of damages. Firstly, it doesn't value the correct thing. As I've said, Your Excellency is supposed to be valuing the costs associated with performing the contract. And if you include the cost of ramp down, you're not doing that. You're valuing the cost associated with providing gratuitous, non-contractual services. That's not the loss of profit which would have been earned under the contract. So even if it was right that as a matter of fact the claimants would have done this, would have just given away what we say is about $9 million worth of free services at their own cost, we say that is not something that you should take into account in assessing the loss of profits under the contract. That's taking contractual loss profits. You're saying, well, the loss profit would have been, we say $18 million, but the defendant would have done something non-contractual after that had finished at their own cost. But that's not the quantification of the damages. So if you, so we say we don't accept that this is a realistic approach to take to the facts. We don't say that it is realistic to conclude that the claimant would have done all of this for free. But even if you do say, well, that's what would have happened, we say that is not the contractual profit. It's something else. You don't bring it into account, whether or not those free services would have been provided. And one can think of examples in more sort of simplified context. So say for example, I'm decided to sell an object. So say I'm selling my car to someone and I agree a good price for it. And it's better than, say they agree to pay twice what it's worth. And then they pull out of the contract. Normally, I'm entitled to the price they would have paid less the actual value of the car. That's my lost profit from the deal. If I say, well, when I sell cars, I'm normally very generous and I'll normally give the party a full tank of petrol, that doesn't affect the loss that I've made by them not pursuing the deal. That's something quite separate. That's not my lost profit from them failing to buy the car as we agreed. My lost profit is just the difference between the price and the value of the car. We don't also knock off the price of petrol that I would have incurred by being generous and giving that to the other party. So we do say that as a matter of principle, it's not something that you can take into account in calculating the claimant's lost profit. But we do also say that it's just unrealistic to suggest that the claimant would have provided those services for free. So if you picture the assessment, on our numbers, The claimant gets to the end of year 3 and they've made about $18 million. It's not quite that much because it includes interest on the calculation. So it's not quite that much. It's probably less, but I can't give you the exact figures. But say it's 18 million. That's the product of 3 years of work, 3 years of investment by the claimant in this contract, plus about a year's worth of preparatory work in putting this deal together, negotiation, disruption, all of that. Then termination comes, and this is supposed to be a long-term contract. That's what the anticipation was. The claimants think this is a 4-year contract, but actually it's being terminated after 3 years. And they're being pushed into this position by the defendant. They're entitled simply to wind down their operations, take their money, and go home. And the effect of the defendant's case is that they are then saying, well, no, I'm not going to do that. What I'm going to do is I'm going to incur massive costs to help the defendant out, to give them services for free, which is essentially giving away half my profit from the whole transaction for nothing, for nothing at all. So we do say it would not have happened. And we do say even if it did happen, it's not something that you would take into account in assessing damages, because it's not a loss that would be incurred in performing the contract. It would be a loss incurred after the contract was completed. And my learned friends, part of my learned friend's answer to this is to say I'm not allowed to raise this point. And we all know litigation would be much simpler if we could stop our opponents raising difficult points against us. But his position is that this is contrary to the evidence and it's a change of case. And we say that is simply wrong. Firstly, if this was inconsistent, if the position I'm telling you about was inconsistent with something you had found in the judgment, then my own friend might have a point. But it isn't, and he doesn't identify any particular part of the judgment which could be inconsistent with this. It isn't inconsistent with the judgment. It's open to me to make this point. Nor does he identify any pleading that has been departed from. So he can't point you to something that I've said in my pleadings. It doesn't even amount to a pleading point. The reality is that the court has decided some of the issues of quantum, but some issues remain to be decided. And that is very often the case with modeling quantum. It's very often in a complex quantum calculation, an iterative process, and issues emerge subsequently from the different positions that the parties take. There's no prohibition on raising those sorts of points. And fundamentally, the court's primary concern is to get it right, to reach the right result and make the right assessment. So the focus really ought to be on whether I'm correct that these are not, this is not a cost that the claimant would have been obliged to incur under the contract. And by the way, we say, if anyone's raising new points, my learned friend is raising new points, the argument in particular that the ASP hosting fees would apply in the runoff period is new. You won't find that anywhere else. But they can raise that point if they want to, and they have raised that point. We say they're wrong about it, but it shows that points of difference can emerge from this process, and we can present them to the court for the decision. But primarily, we don't accept that somehow we've conceded either that these costs would be incurred, or that they should be incorporated into the assessment of damages. And even if we had conceded that, we're not bound to it. It's a legal point. It's about the obligations that arise under the contract. And as Your Excellency knows, I mean, even if I conceded the point and then sought to raise it on appeal, if it was a legal point, it could be raised at that stage. But we don't say we've conceded it. My learned friend says, well, the point is inconsistent somehow with the evidence. And he refers in his skeleton argument to evidence from Mr. Saliba, who was one of the witnesses for the claimant, and Mr. Cottle, who was the expert accountant. The first point to make about all of that evidence is that it was presented on the footing that the contract would last for a minimum of 4 years. All of that evidence was, with the 4th year being by far the most profitable. So by removing that 4th year from our calculation Your Excellency hasn't reduced the damages by 25%. You've cut them in half because the fourth year by that point would have been, the most profitable stage. And that changes the calculations entirely. So the question which was being addressed by all of that evidence was not, as it is in the present 3-year scenario, would the claimant have thrown away half of its profits for the entire transaction on providing these free services? But then if you actually look at what the evidence actually says that's relied on, it doesn't support my learned friend, we say. So the position is set out in I don't know if you have my learned friend skeleton to hand, but it's paragraph 37.3. If not, I'll just read out the relevant section, where my learned friend refers to Mr. Saliba's evidence, and he refers to bits of the evidence where Mr. Saliba anticipated that lives would be handed back gradually and that staff would be reduced to match the gradual handover of lives. And my learned friend takes you, for example, to a section of the transcript. And if we go there, it's on page 1306 of the bundle. And he refers us to pages 39 to 40 of that transcript. So you've got to start at the bottom left of the page. And I mean, you will read that in due course. But essentially, it's going through the association between, firstly, the question of whether there would be a gradual hand back, and the question, if you look at the bottom of that line 20, I believe this is sort of broadly where my friend is referring to. It says, quickly on the ramp down period, you say it's reasonable to assume that lives might migrate back to OIC over a year. That's a matter of opinion, isn't it? No, it's a matter of fact, because usually the ramp down or giving back to an insurance company its portfolio is preferably to be done on a runoff basis. So on renewal, the TPA will transfer a specific group because the business of an insurance company comes monthly renewals, so it's not bulk. So usually the insurance company, they prefer to get back their portfolio on a runoff basis. So on each renewal, they'll say, we will renew this group at our levels. That's why we call it a runoff, giving back portfolio. So what he's saying is, usually that's what insurers want. They want their lives back gradually. And of course, it's a matter for the insurer, for the defendant, when they get their lives back. It might well be gradual, but it has to come before termination. So they can either have them all back on the day of termination, or if they want to, they can have them back gradually over the year previously. And if they want them back after termination, well, that can be agreed, but not without cost, at a cost to be negotiated. So Mr. Saliba was not talking here about a 3-year scenario when you have this termination very early in the process. And he wasn't saying that Globemed would have provided post-termination services for free. He's saying that is what I would expect the insurer to want, a gradual handback. But the consequences of that have not been modelled, because they would either have reduced the claimant's cost and increased profit, or they would have required separate fees post-termination. My learned friend also points to the expert evidence in his skeleton argument. He points to things said by Mr. Cottle. But this is where we have a fundamental disagreement about the role of the experts in this case and the way in which Mr. Burrows, for the defendant, has approached things. Expert accountants are expert accountants. They're not experts in the insurance industry. They're not here to tell you how lives would be managed under a contract of this sort, how the portfolio would be transferred back. They're not here to tell you what the contract means or what its terms require. Now, Mr. Burrows, in his joint statement, feels able to tell you about issues like that, but he shouldn't. He's here to calculate the consequences of the assumptions which are provided to him. And actually, fundamentally, there's no real difference between the experts on the outcomes once the assumptions are determined. And these are not issues that they are expert in or should be expressing views on. And that's the approach that Mr. Cottle has adopted, and that is the correct one. So, for example, the other point to make is that Mr. Cottle was also, as I've said, assessing the 4-year scenario. So, for example, in my learned friend skeleton at 37.1, he says Mr. Cottle in his first report defines ramp down as the transfer of OIC lives between January 2019 and December 2019. But now my learned friend's case is, well, actually, there would have been a ramp down between January 2018 and December 2018. We're looking at different periods and different circumstances. But the fundamental point here is that neither expert can offer evidence on whether Globemed was obliged to provide services after termination, whether it would have done so, or whether that should be included in the calculation. That is a question of law, which is for you to decide on the basis of submission and not evidence. And certainly not evidence from expert accountants. There's some suggestion by my learned friend that lives couldn't be handed back all at once because that would be disruptive to the clients and to the policyholders. Now, I mean, the short answer to all of that is a problem for the insurer to manage. That's the defendant's problem. So the defendant has contracts with clients as an insurer to manage the lives. That's the primary obligation to the clients is owed by the defendant. What's happened under the TPA agreement is that the defendant has subcontracted out that role to the claimant. And so if the defendant wants to terminate that subcontract and terminate Globemed's role, it needs to find another way to service its clients. You can't terminate your subcontractor and then just expect them to continue to provide expensive services for free at great cost to help you meet your obligations to your own clients. It's the obligation, the responsibilities on the insurer to manage that transition. So OIC's position, the defendant's position, is that from termination at that point, they would have, sorry, not their position in these proceedings, but the result, the consequence of termination is that they've got no one to provide those TPA services for them. So they need to do it themselves or pay someone else to do it for them. And if that requires a gradual transition, if that's what they want, then that's what they need to arrange and pay for. But ultimately, even if all the evidence showed that the claimant would have done this at their own cost, we say again, that is not something you take into account in calculating the profit from the contract, because it's not a cost of fulfilling the obligations under the contract. In relation to ramp down, Mr. Cottle has also prepared an alternative calculation. You'll see that in the joint statement, which assumes a shorter ramp down of something like 5 months. The result of that is that because fees start being earned earlier than lives are brought on board, the result of Mr. Cottle's calculation is that there is a 5-month ramp down to ensure that there are 3 years of fees matched by 3 years of services. Because of the way that the contract started effectively in the middle of a year, termination comes after 2.5 years of services, effectively, slightly more. So what Mr. Cottle has done is he's prepared another calculation which assumes a shorter ramp down, not a full year, which is which might be viewed as a commercial result or a fair result, because everybody's getting what they paid for. 3 years for 3 years. We would still say that is not the proper basis to value the profit which would be made from the TPA agreement. It would be that would be Globemed again deciding to provide free services after the contract as a matter effectively of goodwill. Will you excuse me for just a second? Thank you. Sorry, my battery was running low. I think I'm plugged in now. So, Your Excellency, those are my submissions on ramp down. Unless you've got any questions in relation to that, I was going to move on to the remaining issues. All right. So, the third issue in the 7 was this question of staffing threshold. the ramp down period, as I've said, affects costs quite considerably because it has the claimant providing effectively free services for a year. A significant part of that cost is staffing. And so a lot of the staffing cost differential is the result of the ramp down. But there is this other discrete issue about staffing. We say this is just results from a mischaracterization of the evidence of Mr. Cottle, who was the claimant's expert. Now, the issue arises because, in effect, the experts have taken a number of lives as a threshold beyond which the claimant would have had to onboard more staff to have the capacity to deal with those lives. So Mr. Burrows for the defendant says that that threshold comes at 205,000 lives. And he says he gets that from Mr. Cottle's calculations. In fact, the correct number is 276,000 lives. The precise number is 276,460. And that derives from Mr. Saliba's evidence, and that was the basis for the calculations that came previously. So I'll just show you that very briefly. If we go to page 127 of the bundle, we're in Mr. Saliba's witness statement, and if Your Excellency scrolls down to paragraph 114, you see there, Mr. Saliba says, I note that based on my review of the data produced by OIC, GMGHS had adequate staff to service OIC's portfolio immediately following the launch date and during a ramp-up period in which 276,460 lives would be transferred to GMGHS by the end of 2015. So that was the sort of primary evidence. Effectively, Mr. Saliba was saying that's the number of lives that would have been in the portfolio. The claimant could have serviced those with its existing staffing levels. And so that was the figure that was used by Mr. Cottle, the claimant's expert. So if we go forward to his report to page 168, and it's paragraph 6.10, you see he's dealing with payroll costs. He says, Mr. Saliba explains in his witness statement that GMGHS had adequate staff to service OIC's portfolio and recites that passage from Mr. Saliba's evidence. We can skip the next sentence, and then the reference by Mr. Saliba to 276,460 lives reflects the fact that at the time of his witness statement, the disclosure provided by OIC suggested that this was the number of lives that they insured as at December 2015. So Mr. Cottle, because of that evidence, goes on to assume in a conservative way that that's the maximum number of lives that the existing staff of the claimant could have used. And then in his subsequent modelling, he then applies a simplified approach, which uses annual periods for calculations. And as a result of that, he makes certain compromises in the modelling, but always on a conservative basis. So if you go forward to page 306, you can see this is in Appendix 6 to his report. At paragraph 11 and 12, he explains what he's doing. And this is all explained in the joint statement as well. But he says, as mentioned above, Mr. Saliba considered that GMGHS had adequate staff in place to service 276,460 lives. Under my approach, whereby OIC lives are transferred gradually over 19 months, the total number of lives reaches 276,000 in March 2016. On the basis that circa 276,000 lives are reached in March 2016, in accordance with Mr. Saliba's evidence that staff would be hired a month in advance of being needed, this would result in additional staffing being required from February 2016. For simplicity and to maintain a conservative approach, I've commenced recruitment of additional staff from January 2016, 1 month earlier. So what he's done is he's taken the actual number. He's then just simplified it so you can do it on an annual basis. And what Mr. Burrows has done is he's sort of reverse engineered that calculation and said, well, the effect of that is that you're onboarding staff at a time when about 205,000 lives would have been under management. And somehow this is presented as Mr. Cottle changing his position and stating that actually when he previously agreed 205,000 staff lives could be managed, he's now changed that evidence to say 276,000. But he wasn't ever giving any evidence that 205,000 lives was the threshold, that if there were more than 205,000 lives, that would require more staff. He couldn't give that evidence because he's an expert accountant. He was always using the information provided by Mr. Saliba. As I say, Mr. Burrows has effectively reverse engineered this and said that the effect of his compromise is in the previous model should somehow be applied when we're starting again with the new model. But there's no basis to do that. All that this shows is that Mr. Cottle simplified things in his model, in his original model, in ways which were conservative and reduced the calculation. Mr. Burrows doesn't offer any evidence that 205,000 is the correct figure. He can't offer any evidence to that effect because he's an accountant. He just says, oh, well, that's the effect of Mr. Cottle's simplification in the first model. But here we are not simplifying the same model and we're not doing the same assessment. We can use the accurate number, so we should use the accurate number. Mr. Burrows' number is completely arbitrary because it's effectively the result of cutting corners in a completely different model. So again, if the court's concern, as it should be, is to get the right result, then Your Excellency should use the right number. That's the discrete issue on staffing levels, and that's what it comes to. It is, we say, just a mischaracterization of what has happened here. So the fourth issue is nominally staffing reduction after termination. So how quickly and when would staff be let go to reduce, in light of there being no further need to manage lives? Now that turns, we say, primarily on ramp down, because obviously if there's a year of ramp down, then the speed with which staff would be terminated would need to match the lives, and we accept that. But if you calculate on the basis of the claimant's contractual obligations, we say, then that should be the end of that, and you can assume that staff will be terminated on the date of termination because there would be no more lives to manage after that. But my learned friend has some further points on this to say that, well, even if in those circumstances that might be right, even if there was no ramp down, then they couldn't do this. Now he addresses this at paragraph 45 of his skeleton argument. And what he says is, in any event, even if there were no ramp down period, that would not likely lead to an immediate cessation of wage payments in circumstances where staff are likely to have notice periods. I mean, that's just a duff point, because Globemed would have had 12 months notice of termination. So it's able to say, we know in 12 months' time, we're going to hand all these lives back. From that date, we're not going to need any more staff to manage lives. So say that there's a 3-month notice period in these people's employment contracts. All you do is you wait 9 months and then you give them notice of termination in those 9 months. The fact that they've got a period of notice in their employment contracts doesn't mean you can't make sure that their contracts come to an end on the right date. You don't just get to termination and think, oh, well, actually, turns out we haven't got any more lives to manage. Let's think about letting some people go now, and then having to give them notice on the date of termination. You give them notice before the date of termination in anticipation of termination. There is another point which is raised in my learned friend's skeleton argument at paragraph 46.2. I'll just pick that one up. What he says is, in any event, because, as Mr. Burrows points out, it's an unlikely factual scenario for GMG to simply cut 31% of its staff at a time when the full portfolio of lives still required management would lead to an enormously uncommercial and unsatisfactory position, whereby the same number of lives, at least initially, were being managed by a significantly reduced staff with almost no management guidance. That would likely lead to poor service levels and unsatisfied customers, brackets, for which GMG would be accountable to OIC. And then says it's not something a reputable company would do. OIC is surprised that GM suggests it would have acted like that. So my learned friend's position is, well, the lives required management after termination, and GMG, the claimant, would be accountable for the defendant for poor service levels, even after termination. But we say that's just plainly wrong. The claimant was not obliged to provide any service levels after termination, save for claims management services. The lives have to go back at some point. After that point, the defendant takes responsibility for the service levels in relation to those lives. And contractually, if I'm right, then that point was termination. So what we say is that this just shows that the defendant's approach is based on a false assumption, which is that the claimant was obliged to manage lives after termination, when in fact it wasn't obliged to do that. It was just obliged to run off claims. So we say the reduction in staffing follows the ramp down decision. And if we are right, then there should be an immediate reduction in staffing on termination. Issue 5 then is ASP hosting fees. And as said, this is about sums which were due under the franchising and license agreement to another Globemed company for the technology systems for hosting the management of the lives. And the amount of the fees that were due depended on the number of lives that were being managed. So that the more lives that are managed, the higher the fees. So if there are lives managed after termination, then of course there are going to be more fees associated with this. So this is another cost that goes down if there is no ramp down and goes up if there is a ramp down. However, there is this new point that the defendant wants to raise, because what it says is that even when lives were at 0, there would be a cost. So even during the runoff, they say, there would be a cost. And there are two answers to this. The first answer is when you actually look at the contract, that is not what it is intended to say. So this turns on the fee schedule in the franchising and license agreement, which you will find at page 1202, 1202.
Yes.
And you will see what that says. So this is setting out the fees that are due from the claimant, which is the franchisee in this contract. And if I can ask you just to look at clause 1.
Yes.
In return to its application service provider services, as identified under the present agreement, Globemed is entitled to get from the franchisee the lower of the following Globemed annual fees, or the competitive market rate for the rendered ASP services for adherents who benefit from in-hospital and any other service whatsoever per the following fees. And then you have the first bracket, and you will see what my learned friend's position is that the first bracket goes to 0. So it applies even when the lives are 0. That's the position that's taken. So according to the defendant, the claimant is obliged to pay a fee even when no ASP services are being provided. So in other words, this is an agreement to pay the minimum fee in perpetuity. We say that the meaning of the schedule is pretty clear. It is saying that the first fee is payable where there are lives up to 25,000. So if there are no lives, there's no fee. That, we say, is the only commercially sensible interpretation. It'd be bizarre commercially if the agreement was to pay fees forever for something that wasn't being used. We say that is plainly the intention of the clause, because if we look at the words of paragraph 1 above, you'll see in the second to last line of that, the payment is for adherents who benefit from in-hospital and any other service whatsoever. So the intention is to calculate ASP fees for adherents who are getting services. The fee requires adherents, that is lives. If there are no adherents, no lives, there are no fees. I mean, one can test it this way. If you look at the other end of the schedule, so if you go down to the bottom, do you see the last, sorry, it's on page 1203.
Yes.
So the fee schedule goes up to 600,000 lives. So the consequence of what my own friend is saying is, well, if it's not, you just, you have to be strictly limited to these, and you read it like a statute. And so, for example, if there were 600,001 lives, the consequence of that would be, well, there's no bracket for that, so there's no fee at all. So you pay 646,000 for full coverage fees if there are 600,000 lives, but if you add a life, that fee goes down to 0 on this logic. One has to read this in a commercially sensible way and understand that effectively what that means is anything above 575,000 attracts that fee. Similarly, when you go back to the beginning, you can't read that as saying if there are no lives, you're still paying the same fee. That's the first point. It's just about the construction of that agreement. The second point is this. Here you're looking, the argument doesn't make any sense anyway, because what you're trying to work out is the additional cost to the claimant of servicing the OIC lives. So when you calculate the loss of profits, you're looking at the revenue that would have been received from the contract, but you're looking to remove the cost that would have been paid, and so the cost that has been avoided by not proceeding with the contract. But on this approach, on their argument, you can't avoid this loss. It would have been paid whether there were OIC lives or no OIC lives, because on their case, there's just a fee that is due. And so the result of their own argument is that there's no reduction in profit as a result of having no additional lives, and that's logical anyway. So in other words, the claimant either has this liability for 0 lives or it doesn't have this liability for 0 lives. But in calculating profits, you're looking to see how the costs would have risen as a result of managing OIC lives. So the whole argument doesn't actually make any sense on a loss of profit basis anyway. And the other point to raise is that there would still be non-OIC lives. So actually, the only issue is whether or not the cost would be increased by adding OIC lives. And if you're adding no OIC lives, then you're not moving to a different bracket. You're not increasing the costs. So there is, we say, nothing in that argument. And you should decide it on the basis of the claimant's calculations. That's ASP hosting fees. There are 2 other issues which are quite short, and I'm going to be much shorter than my 2 hours, but that is no doubt to everyone's benefit. Issue 6 is the question of interest. And this is slightly baffling to us. My learned friend said we should not have interest since the 30th of January 2024, because it should have been possible to agree quantum sooner. And he says, well, we can't have judgment for interest after that time. Sorry, we can't have judgment interest after that time either. And the only reason he gives in the skeleton argument is for the same reason. It's buried in a footnote. And we say this just makes no sense at all. So the purpose of awarding interest is to compensate a claimant for not being paid sooner, not for not getting judgment sooner. It's the actual payment which stops interest, not a judgment. So if a judgment had come earlier, the result would simply have been interest at the judgment rate. So say we had agreed the number 2 weeks after your earlier judgment, then unless the defendant actually paid that money, you'd then have a different rate of interest applying, but a higher rate of interest. The judgment rate of interest would apply. So there's no basis for disqualifying us from interest at all unless and until the defendant actually pays something. And they're saying it was all terribly clear in January. Well, I mean, we disagree with that, and I'll show you something about this in a moment. But if they were saying it was clear what was due in January, they should have paid what was due in January. And if they don't pay what's due in January, then interest continues to run. So if they're saying now it's $8.3 million, they should be paying that 8.3 million and then arguing about the rest. If they don't do that, then of course interest continues to run. And the second point is this: I don't accept for a moment that the need for this process is the responsibility of the claimant. It's the responsibility of the defendant for walking away from this contract in the first place, stringing these proceedings out for years, and then not paying a cent, even to today's date. This is a contract they just walked away from in 2016, and here we are, 2015, sorry, and here we are 9 years later, and no money has been paid. But in light of this, and these sorts of issues arise all the time. I mean, this is absolutely standard that there is a need for a quantum process or some aspect of a quantum process, and it takes time. In light of this allegation, because we'd seen that they were not calculating interest, but it was not explained before my learned friend skeleton argument why. In the face of that, we added some of the correspondence. You cannot see all of the detail of how the parties arrived, how the experts arrived at the joint schedule of differences, because that is privileged material. In terms of open material, what I can show you is firstly what was offered or what was suggested to be the right number, which is on page 1668 of the bundle.
1668. Yes.
And that is, you will see the assertion in that letter was that the sum that was due, you can see it in the middle of the page, the judgment sum was a little over $7 million. So it's about 1.34 million short of the number that they now concede is the right number. So the idea that the right number was obvious and apparent in January is wrong, because in February they're not even offering the number that they now accept is the right number. They're still not actually offering to pay it, and they still, of course, don't pay it. So the whole point's academic, as interest continues to run. But as I say, they now concede the number is bigger, $8.34 million. And that figure is only confirmed in their joint statement on the 30th of May this year. So whatever that was, about 4 weeks ago. And you won't see that figure in any correspondence. So even if they are correct on every single point that they raise, and I say they're not, it's not until the 30th of May that we could have got what we were entitled to as a judgment by agreement. We could have said at that point, right, we accept your numbers in the joint statement, 8.343 million, it is. And of course, we say they're not right on every point. And if they're not right on every point, then your Excellency's final judgment will be higher than that. We say it should be much higher and should be closer to the 18 million. But it does show that quantum could not be agreed in January. My learned friend suggests it required discussion to get the right figure, even on their best case. And that's the normal consequence of a party simply refusing to follow through on its contractual obligations, which is what you have found that they have done. Now, fundamentally, though, this is all academic because they haven't paid anything. They should be making an interim payment of 8.3 million and saying, right, let's argue about whether anything more is due. So I would ask Your Excellency to give that particular argument some pretty short shrift. Yes. And then the final issue is the non-OIC damages. And again, we have here a disagreement about the meaning of Your Excellency's judgment. You've already decided the issue, so you don't need to go to the evidence. You just take you back to your judgment. If we go to page 84, please. And paragraph 101, you're here settling on having found that we say all of the non-OIC claim was more likely than not. You apply the test of certainty, and you are saying some of it was certainly suffered, but not all of it. And you're trying to, and you go on to calculate how much. You say the word sum is necessary and specific. I value GMG's inevitable non-OIC losses at 25% of GMG's total non-OIC claim for each year for the duration of the TPA agreement. So you've limited the claim in two ways. Number one, you've reduced it to just the 3 years of the contract, because obviously we claim for a longer period, and then you've applied 25% to it. And then if you go down, please, to page 91 in your disposition.
Yes.
Sorry, I'm going to have to scroll. It's paragraph 126. Is that 91? Yeah, paragraph 126E, which is where you say the non-OIC losses are assessed as being 25% of GMG's total claim for non-OIC losses for each year for the duration of the TPA agreement. So what we've understood that to be is we've taken the total claim and we've applied 25% to it. The defendant's done it differently. What they've done is they've taken the size of the portfolio that we were claiming the claimant could have attracted, and they've reduced that to 25% of the portfolio, and then they've run a calculation on the basis of that. So there's a disagreement. We say it's pretty clear to us what you meant. Your words mean you take the claim, apply 25%. That's what we've done. They've done it differently. It doesn't matter hugely, but as we say, the court, we ask you to be cautious because you are being led into giving support to a ground of appeal. You may have seen this. If we go to page 1514.
Yeah.
And it's paragraph 58.1. This is one of the grounds of appeal that they advance. They say by awarding 25% of GMGS's claimed non-OIC losses, the judge essentially recognised that the loss claim was on balance unlikely to occur. That's to apply something akin to a loss of a chance approach, which is inapposite, where the test under UA law is whether the loss sought is certain or inevitable. So you will notice also that, at least in their appeal, they characterise the judgment as awarding 25% of the claimed non-OIC loss, which we say is inconsistent with their current characterisation. In any event, whatever conclusion you reach on this, it is important, we say, to make clear this is not a loss of a chance assessment. It is an assessment of, you've already assessed what is more likely than not. All of it is more likely than not. You are there assessing which part of that you found to be inevitable or certain. And you shouldn't be led into complicating or giving support to the appeal that's being intimated. So, Your Excellency, that's where we get to. You will have seen from the schedule of differences that the sum total of those differences ends up in a number that is reasonably significant difference. You can find it on page 1153. And you will see that the total ranges from the defendant's best case of 8.343 million up to our best case of 18.2 million or thereabouts. And no doubt, as I say, you may decide the issues in a way which leads to one of these scenarios. You may decide them in a way which requires a further calculation. But I am confident that we would be able to agree a number once you've reached a conclusion on these 7 issues. Your Excellency, unless you've got any questions for me, those were the submissions I was going to make.
Yeah, thank you very much. I don't have it for now. Maybe later on when we have the reply. May I ask, if you don't mind, Mr. Timothy, to have a break for 15 minutes and come back more fresh? So we'll break now for 15 minutes and see you later. Thank you.
Thank you.
I'm really sorry for keeping you waiting too much. So.
No,
please go ahead.
not at all, not at all. I think we're doing very well on the timetable, so we've got time.
Excellent. Please go ahead.
I'm grateful. Thank you. Now, Your Excellency, OIC's overall submissions are twofold, and they are relevant to the primary matters in dispute, so ramp up and ramp down. And we agree with Mr. Montague-Smith that those are the 2 issues which have the greatest impact on the overall sum. Now, the first of our overall submissions is that we say that on these fundamental issues, what Globemed is now attempting to do is essentially to run a different case from that which was put forward at trial and which was, for the most part, agreed between the parties. Now, as a matter of principle, we say, of course, Globemed can't now, after a final judgment has been given, and in the guise of attempting to calculate a judgment sum, have second thoughts about the case that it put forward and the positions that it agreed. This hearing isn't an extension of the trial. The trial's over. The evidence has been called, heard and examined. That means that OIC cannot now cross-examine Mr. Cottle or any other witness on their change of position. Factual witnesses can't be called and cross-examined to test the accuracy of their assumptions and the evidence, and the court can't assess those. So we say that procedurally, this is most irregular for positions to be taken at this stage in what is essentially a consequential stage, for positions to be taken which fundamentally alter the positions that were taken at trial. Now, regardless also of the procedural reasons why Globemed should not be permitted to take this course, there's obviously a clear interest in finality as well after a judgment has been given. As I said in my written submissions, trial is not an audition, it's the first and last night of the show. Globemed can't come here now and run a different case after final judgment has been given. What the parties should be doing is simply to apply the findings that were made on the disputed parts of the case, the agreements that were made on the undisputed parts of the case, and come up with a judgment sum. And our submission, in brief, is that if the parties did that, then they come to the circa $8 million figure that has been calculated by OIC. Now, I've made some points in my skeleton with reference to authority as to the importance of finality and the reasons for this in the Vanin decisions, those decisions of His Excellency Justice Al-Madani and also Justice Sir Richard Field. Those were, of course, decisions in an interim applications context. This, we say, is an even stronger case because it is a final judgment. We say that is the start and the end of the matter. We say that you cannot now change an agreed position, change a settled case that was run post the evidential stage, post final judgment. But second, we say, in any event, even if it were open to Globemed to try now and have another bite at the cherry, we say that there were very good reasons why those positions were agreed. Because, as we say, the experts acknowledged, either implicitly or explicitly in each case, they were positions that were unassailably right. So even if it was relevant to consider the reasons that Globemed are now putting forward for the case, we say that analysing those reasons shows that the position they took at trial is in fact the correct position. So, Your Excellency, those are my two overarching submissions, and I will now take in order and in the same order as Mr. Montague-Smith each of the 7 issues that have arisen between the parties, and I hope make good those 2 submissions. First, that the trial, the case that was run by GMG at trial is in fact now being changed. And second, that even if one looks at the underlying reasons, there were good reasons for those agreements and the case being run at trial. So starting then with ramp up. To recap, of course, ramp up is how the experts have referred to the period during which lives would have been transferred across from OIC to Globemed after the launch period. And ramp up matters, as Mr. Montague-Smith explained, because the administration fee income due to Globemed under the TPA agreement is calculated based on the number of lives that Globemed manages at the end of each contractual year. So the number of lives that it has at the end of each contractual year, and specifically in the context of ramp up, the first contractual year, impacts the administration income that it gets and therefore the profits that it can claim. Now, OIC's calculation provides for a ramp up period of 12 months, and that is on the basis that lives would have transferred across on their renewal or inception date. So each time a health insurance policy was renewed, it would then move from OIC to Globemed, or each time a new policy was placed, that would then be placed with Globemed. Now, because health insurance policies are usually on an annual basis, the period of 12 months was taken because that 12-month period then captures each of those renewals or inception dates. Now, Globemed's calculation assumes rather shorter ramp-up periods, and it's roughly, I think, about 6 months for the non-Bupa lives and 3 months for the Bupa lives. And so that means that in their calculation, all of the lives are transferred across by the end of the first contractual year. So they get the maximum administration fee income in that first year. Now, as I understand it, the only basis, and we say it's a slim basis, on which Globemed claim to be able to do this is because of paragraph 86 of Your Excellency's judgment. Now, I have two primary points, as I've said, for why paragraph 86 cannot reasonably be taken as saying any such thing. First, we say that that approach is in direct contradiction of the case that was run at trial and the position agreed between the experts. And second, there are good reasons for that position being taken. So essentially, if the court intended to make a finding in paragraph 86 that was contrary to the position as it had been agreed and contrary to the unchallenged evidence, then the court would have said so. And it doesn't. And because it doesn't, the strained interpretation that Globemed puts on paragraph 86, we say must be wrong. There's also a third point that we make, which is an ancillary point, which is even when you read paragraph 86, if you read it in the context of the rest of the judgment, and that's even not taking into account the agreed position and the underlying evidence, we say that paragraph 86 cannot sensibly mean what Globemed now contend for. So I'll start then, Your Excellency, with the position which Globemed took at trial. And we say that it is abundantly clear that the position that was taken at trial was that lives would be transferred completely by the end of the second contractual year and not the first contractual year. And if I could take you first, Your Excellency, to tab D1, page 135.
135.
And this is Mr. Cottle's first expert report, Mr. Cottle, of course, being Globemed's expert. And this is his glossary, and one can see ramp up on page 135 is defined as the transfer of OIC lives between June 2015 and December 2016 to GMGHS. So one can see there that ramp up has been defined as taking place over a period between June 2015 and December 2016, meaning that it straddles the first and the second contractual year. If one then turns to page 146 and paragraph 4.9 in the same report, Mr. Cottle explains there the basis on which he has prepared his calculation. And he says, I've prepared this report on the basis that whilst it was the intention of the parties that GMGHS would manage the entire portfolio of OIC lives, it was accepted/acknowledged that it would take time for those lives to be transferred from OIC to GMGHS. As a consequence, there would be a period during which the total number of lives insured by OIC would exceed the number of lives transferred to and managed by GMGHS. By reference to an email from OIC dated the 24th of February 2015, it is evident that OIC considered the runoff of lives from OIC to GMGHS would take place over an 18-month period, April 2015 to October 2016. Given the launch date subsequently moved to May 2015, I've assumed a deferral of the transfer of lives such that by 31st of December 2016, GMGHS would be managing the entire portfolio of OIC lives. Now, Mr. Cottle uses the phrase runoff of lives from OIC there, but what he is talking about is the ramp up of lives from OIC to GMGHS, so the movement of OIC to GMGHS. If one then turns to paragraph 5.22, which is at page 160 in the same report, further detail is given by Mr. Cottle of the ramp up. And he explains here that the data disclosed by OIC did not contain any information in respect of the policy start or renewal dates, and therefore I'm unable to determine on what date an individual would have commenced or renewed their insurance policy with OIC, and hence when they would have transferred across to GMGHS. So pausing there, what Mr. Cottle is confirming is that his calculation assumes the movement of lives from OIC to GMGHS to be on a renewals basis, and he recognises there that the date of renewal is important. He then refers to Mr. Saliba's witness statement and says it is reasonable to assume an even distribution of policies over the year and a largely consistent monthly transfer of lives, both in respect of the initial contract year and also in respect of each subsequent contract year. And he says then that he's assumed that policies are renewed and lives transferred evenly over the policy period or year. So he's essentially saying there that he doesn't know exactly when each of the policies renews. So he's assumed that they'll be doing it smoothly across the year, and that's how he's managed his calculation. So he's applying a ramp-up period of 1 year of 12 months from the launch date, which takes him through into the second contractual year. Paragraph 5.32 then puts a bit more detail to this, and that's page 162. And he says here that in the first year of the agreement, I've assumed that GMGHS would be managing 204,000 out of 332,000 OIC lives. So he's therefore done his calculation, and he's worked out that of the total OIC lives that were going to be transferred across, about 2/3 of them would have been transferred by the end of the first contractual year. And he explains the point that I made at the start at 5.33, that under the agreement, Globemed is entitled to receive a fee based on the number of lives that it manages at year end. So that's why it's important. And we then have Appendix 4, which starts at page 201, which sets out again the assumptions regarding the ramp up and ramp down of lives. And paragraph 3 onwards is the handover of lives in 2015 to 2016. And again, paragraph 4 of this makes clear what's already clear from the rest of the report, that by reference to the email 24th of February, the intention of the parties appeared to be that the initial transfer would be spread over an 18-month period. This would equate to 100% of OIC's portfolio transferring across to GMGHS by November 2016. So it is absolutely clear that the basis of Mr. Cottle's calculations included a ramp-up period of 12 months, and that ramp-up period was assessed on the basis of renewal dates and the policies being transferred across at renewal dates. Now, Mr. Cottle's second report goes on to then explain that he did in fact get the information subsequent to his first report on when the actual renewal dates were. So rather than simply assuming an even spread across the year, Mr. Cottle's then able to say when precisely each policy would have renewed, and so when it would have transferred across. And we can see at tab D5, page 1010, and this is at paragraph 3.7.
Sorry, the page number again?
1010, Your Excellency.
Yes, thank you.
And we can see here paragraph 3.7. So this is Mr. Cottle's second report, his supplemental report. And he explains here that he's been given new disclosure from Mr. Burrows's first report containing the information on policy start and renewal dates, which I would have used in my first report had it been made available to me, and that this allows him to update his loss model. And then if one turns to page 1015, one can see that at paragraph 3.30, table 3, he now knows, and if you may recall, his original assumption was that 204,000 lives were going to be transferred across on an even spread basis by the end of the first year. His calculation is now that 205,000 lives of the 332,000 lives would have been transferred across, because there must be some slight quirk in some of the renewal dates that meant that slightly more would have been renewed before the cutoff of the end of the first year. So he still applies the same calculation, he still applies the same method, he still applies the same ramp-up period, but he now has the actual renewal dates with which to do it. But it's very clear that that is still the way that he calculates it. And he calculates it again that roughly 2/3 of the lives have been transferred across. Now, just to show that by the time of trial, nothing had changed, it was Mr. Cottle's evidence on day 3 that this was the basis on which he was calculating the loss. This is in the transcript at day 3, which is tab F1, page 1306. And my learned friend took you to this already.
Yes.
And in his oral evidence, the answer that he says is no, this is a matter of fact, because usually the ramp down or giving back to an insurance company its portfolio is preferably done on a runoff basis. So on renewal, and I'm very sorry, actually, I think this is Mr. Saliba's evidence. So on renewable, TPA will transfer the specific group because the business of an insurance company comes on a monthly basis, on monthly renewals, so it's not one bulk. I'm very sorry, my lord. I think that's actually a bad reference. I think that is my ramp down. I think the page I wanted to turn to was page 1379, which is Mr. Cottle's evidence, and that's tab F2.
1379, yeah.
Yes, thank you. And Your Excellency, if you can see the internal transcript, page 133, this is day 4 of the transcript when Mr. Cottle was giving evidence.
Yes.
But be grateful your reading of the other one was not wasted, because it'll save me going to it again when we talk about ramp down. But sticking with ramp up, Mr. Cottle here explains the basis of his assumptions. And in the first answer, line 4 of page 133, he says, I think we assumed that by December 2015, 205,000 lives would have actually transferred across. Even though OIC had 335,000 lives, we assumed that it would take circa 18-19 months to actually ramp up to that sort of level, so a significantly lower number of lives than was assumed within the MOU forecast. And then over the page, on page 134, bundle page 1380, Mr. Cottle again explains, starting at line 5, at that stage, I'm at only about 205,000, which I think is broadly the same as if we're on a like-for-like basis, and I appreciate there are differences between Mr. Burrows and myself. I think we agree that if we take the same factual basis in terms of, including Bupa, not making any deduction for other TPAs, I think we are both at the same number of lives, because we both use the policy renewal dates as the rate at which lives would be transferred across. So Mr. Cottle's evidence, which is confirmed by Mr. Burrows in the joint schedule for this hearing, was that the experts were agreed on this renewal basis ramp up. So, Your Excellency, what we say is that, of course, the judgment wouldn't have made a finding that there was no ramp up or that ramp up was different because it simply wasn't in dispute. The job of the judgment is to make findings on disputed points, and that's what the judgment did.
Yes.
And so you can't now read the judgment saying, well, there was a different finding that was made to a point that was agreed that was not in dispute, and then we'll apply that to our benefit now. So, my lord, and just for Your Excellency's note, page 135 of the transcript on the same page, it's also confirmed their question, line 11, the transfer was going to happen over a year, wasn't it, on the policy renewal dates? And then Mr. Cottle says, in the MOU, I think it was assumed over a year. I think Mr. Burrows and I both assumed a transfer rate of 18 or 19 months, I think. So again, just confirmation there of the position. Now, that, I hope, makes good my first submission that the ramp-up position, now taken by Globemed, is completely inconsistent with the position that was run at trial and that was agreed between the experts. Now, Your Excellency, if I'm right on that, that's the end of it. That is that point answered. But nevertheless, my learned friend has made some submissions on why that position has changed, apparently because of 86, paragraph 86. And so we say that it's probably worth having a quick look at the terms of the contract as well, which Mr. Cottle referred to in that section at page 135 of the transcript, that shows why the experts agreed it. So we say there was good reason for the agreement because the TPA agreement itself envisages this. And the TPA agreement is at tab E2, and it's page 1245 is the relevant clause, which is clause 5.4.
Yes.
And we can see there that the TPA agreement expressly deals with how lives would be transferred across. And it says the parties agree that till the time the existing medical portfolio is transferred to Globemed, which is due upon their renewal as per agreed timeframe. So we say that's why the experts were in agreement. That's why there was no dispute about it, because the TPA agreement was very clear that it was being done on a renewals basis. So we say that clearly that was the position. Second, clearly there was a good reason for the position. So we say that reading paragraph 86, it can't possibly mean what my learned friend says it means. But I had a third point, which was a slightly more forensic point, which is that even if one forgets all of that, puts that to one side, when one reads in context what is being said at paragraph 86, it clearly isn't saying what my learned friend submits it says. So to make this point good, if we turn to Your Excellency's judgment and start at page 75, that's behind tab B1. And we can see here just above paragraph 73, the subheading Bupa. So clearly what's being discussed here is the Bupa portfolio. Now, I have a point on the fact that what Globemed appear to try to do is to transfer the finding which we say wasn't made in the context of Bupa to the entire portfolio. Well, we say that's dangerous in circumstances where what this part of the judgment is addressing is Bupa. But more fundamentally, the question that is being addressed is set out and is clear from paragraph 77. That's over the page at bundle page 76. And the question is, we can see from the second sentence there, whether the parties expected that Bupa might consent to the transfer within 1 month of the MOU by at least 14th of May. And one can then see, as one goes through, what's being discussed in this part of the judgment is the question of Bupa's consent. Now, that's important because the question was whether Bupa would have consented and by what date. Once the consent is given, then the parties apply the thing that wasn't in dispute, which was the transfer on a renewals basis. And paragraph 78, over the page at bundle page 77, one can see again that what is being assessed there is, in my view, could only be consistent with an interest, though not necessarily an unconditional one, in consenting to the transfer. Paragraph 79, in my judgment, Bupa was willing to consent to its portfolio being managed by GMG. Paragraph 80, in the middle of that paragraph, it should be highlighted insofar as this statement may seem self-serving, that while evidence that Bupa would consent to the transfer is in this case in GMG's favour. Again, at paragraph 82, OIC considered Bupa's consent was becoming increasingly unlikely. And then paragraph 84 is where the point is really hammered home, starting bundle page 79, sentence, moreover, OIC was at financial loss if there was so much as a delay in Bupa's consent. Next sentence, meanwhile, while Bupa may not have rushed forward to consent to the transfer of its portfolio, again, it was willing to consent to the transfer. Further in that paragraph, nearly all the evidence points towards Bupa consenting. And then last sentence, indeed, it would be difficult to support a position with the evidence before the court that any of OIC, GMG and Bupa would not continue to put in effort until Bupa was content to give its consent to the transfer. So the whole of the context of the discussion at paragraphs 85 and 86 is the question of whether Bupa would consent. It was never an issue that once the consent was given, the transfer itself would happen on the renewals basis. And we say that reading paragraph 86 in that context, the key sentence, the sentence that makes this clear, comes at the end, starting when this evidence is combined. It says, when the evidence is combined with the fact that 15th of January 2016 was 2/3 of a year later than OIC was working for Bupa to consent, and the conclusions I have come to generally, I think it is fair to conclude that Bupa would have inevitably consented by that point in time. So paragraph 86 is only dealing with the question of the timing of Bupa's consent. It is not making any findings on the actual date of transfer, and the reason for that is because that wasn't in contention. So we say that this is a remarkably opportunistic reading of paragraph 86, which reads that paragraph in isolation, ignores the case that GMG ran, and ignores the reasons for the case that GMG ran. So we say simply and clearly, there very much was a ramp-up period that was not in dispute between the parties. And so in calculating the judgment sum, that ramp-up period needs to be applied. So, Your Excellency, my submissions on ramp-up are as simple as that. I propose then to turn to ramp down, unless there are any questions that you have that would be helpful to ask at this time.
No, please proceed. Thank you.
I'm grateful. So, turning then to ramp down. Now, I'm afraid to say that if GMG's approach to ramp up is opportunistic, well, I'm afraid that its position to ramp down is rather more shameless. So just to recap, ramp down is the period after the contractual period during which Globemed would still have been managing lives on behalf of OIC, and so incurring the cost of managing those lives, but would not have been entitled to any further administration fees. Now, the reason for that is because, as we've touched upon already in the context of ramp up, the way that the fees are calculated is that Globemed was to be paid based on the number of lives it managed at the end of each contractual year. So it's already been paid in the year before for the lives that came in that year, but it has to continue managing them into the year after. Now, for the purposes of this hearing, OIC has calculated a 12-month ramp down. GMG has calculated on its primary position no ramp down at all, or it's got an alternative case of 5 months. Now, OIC's case on this is again twofold. First, on the basis that the important, compelling point that Globemed's own evidence and case at trial was that there would be a 12-month ramp down period. And so again, we say, if that's established, if that's right, then that's the end of the matter. But we have a second point as well, which is that if one looks to the merits of the point, so why did the experts agree a 12-month ramp down? Well, there's a slightly more forensic point that there's a good reason for the inclusion of the ramp down period, and it depends on one of the positive findings that Your Excellency did make, which was the basis on which interest was to be calculated, and the fact that it was to be calculated on an entitlement basis. And we say that it flows from that finding that this is how ramp down must be calculated. So it's something that has had a positive finding made on it, and it was done for a very good reason. Now, turning then, as I did last time, to making the first point good, which is that this was GMG's own case, that there was a 12-month ramp down period. Mr. Saliba gives the first evidence on this, which is at page 129 of the bundle, tab C1. And he has, rather helpfully, a section of his witness statement entitled The Ramp Down Period. Paragraph 125 says, rather straightforwardly, in circumstances where the agreement was not renewed at the end of its term, a ramp down period of 1 year would apply. Now that's pretty straightforward, we say. He's saying there's a 1 year ramp down period. Now that's precisely what Globemed are now saying there isn't. But he goes on to explain what this is and why this is the case. He says, during this period, I expect that the number of OIC lives that GMGHS managed would gradually decrease as GMGHS transferred them back to OIC on the insured member's insurance policy renewal date. So that, we say, makes abundantly clear not only that there's ramp down, but the reason for the ramp down. It's essentially the obverse of the ramp up, because they hand them back on that basis. Now, we say that it's very clear that this was also the basis of Mr. Cottle's calculations. And one can go to the appendix 4, which we were in just now, to the first report, which is page 202. And paragraph 9 of that, and the sentence starting, I likewise, and this is under the heading, one can see at the top of the page, the handback of lives in 2019, brackets ramp down. He says, I've likewise adopted the same approach in year 5, and that's of course because he was calculating a 4-year contract period. So he says this ramp down on his calculation happens in year 5, but Your Excellency, having found that the contract period is 3 years, we say it happens in year 4, but contrary to what my learned friend suggested, there's no fundamental difference between a 4-year contract and a 3-year contract as to how ramp down applies. Ramp down is simply the process at the end of the contract period, whatever that is. And he says here, I've adopted the same approach in year 5, for which we ought to read the last year, or the year after the termination, so year 4, when I have assumed that the number of OIC lives managed by GMGHS decreases from the 688,513 that existed at 31st of December 2018 down to 0 by 31st of December 2019. I have applied the same assumption on ramp down, i.e. that lives would transfer back on a linear basis as I applied in the ramp up period. So he's saying there that it's on policy renewal, and he has made that smoothing assumption that it's done evenly across the year. One can also see, page 135 of the report, again in the definitions, that ramp down is defined. And again, this makes it very clear what is happening. So the transfer of OIC lives between January 2019 and December 2019 back to OIC following the notice period. So again, that is a 1-year period during which the lives are being transferred following the end of the notice period. So at the end of the contract. Now, this position was also maintained by Mr. Saliba in cross-examination, and I, in error, took Your Excellency to that earlier, so I'm not going to go back to it. So we say it is abundantly clear that GMG's calculation was put forward on the basis of there being ramp down, and on the basis that ramp down would be 12 months, because that accounts then for an entire cycle of policy renewal or inception dates. Now, second, we say that in fact, there being a ramp down is essential and was central to the quantum case that Globemed ran. Now, the reason for that is the ramp down period allows Globemed to calculate revenue on an entitlement basis, and that increased its interest calculation. And Your Excellency may remember there was an argument at trial over whether interest ought to be on an entitlement basis or an accrual basis. And Your Excellency made a positive finding that Globemed Gulf were permitted revenue to be calculated on the entitlement basis. We can see that from page 52 of the bundle, which is the order, the final order given with the judgment. And we can see it number 7 of the order. In relation to the interest calculation, revenue is to be counted on the entitlement basis. Now, what that means is essentially that because of the structure of the TPA agreement and the fact that Globemed is entitled to the fee for a life where that life is being managed by it at the end of the year, then it's entitled in essence to a year's worth of fees, regardless of whether that life is transferred on the first day of the contractual year or the last day of the contractual year. But of course, if it was transferred on the last day of the contractual year, they'd be being paid an entire year's worth of fees for managing that life, but they'd only be managing that life for 1 day. Now, this was the dispute about entitlement or accruals basis, because an accruals basis would say, well, you only account for that amount of money as you provide the services. So you would calculate it on a 1/12 basis if you were doing it monthly, for instance. So if it came in the last month, you'd get 1/12 of the fee. You'd account for 1/12 of the fee in your year. Now, Globemed didn't want to do that. They wanted to calculate on an entitlement basis. So they wanted to account on the basis that as soon as they were entitled to the 1 year's worth of fee for managing the life, that went into their accounts. And the reason for that was that meant they were able to recognize the administration fees earlier, and that increased their interest calculation. Now, the corollary of that, however, is that if you've accounted for this on an entitlement basis, you have accounted for the entire year's worth of fees of managing that life for 12 months in the year in which it was due, rather than in the year in which the services were provided. So you have to provide the services for the year afterwards and account for the costs of those services in order for that accounting exercise to work. So in essence, by having argued for the entitlement basis on interest, Your Excellency having found for Globemed on an entitlement basis, Globemed are essentially now trying to have their cake and eat it by saying, well, you found for us on that, thank you very much, we'll take the longer period of interest, but we're not going to now give you the costs for the actual provision of those services, which would have been provided for in the year after. Now, this is explained very clearly, and I did my best to try and summarize what the position was there, but this is explained very clearly, and it's very clear that this was Mr. Cottle's point in his report at 5.24. So this is in his first report, tab D1, page 160. And one can see there at 5.24 the explanation that Mr. Cottle gives. And he says the effect of GMGHS receiving the entire fee for this life in advance does not result in GMGHS receiving any greater amount of income over the period during which GMGHS services that life. This is because when the policy ends or the agreement ceases, there will be a period during which GMGHS services that life when it no longer receives fees from OIC. So that's the point that I was just making. They've accrued the interest, they've accrued the fee on the entitlement basis in the year in which they were entitled to it. But they're not double counting, Mr. Cottle says, because they're providing the services the next year. And there's a diagram which shows that diagrammatically over the page at page 161, figure 1. So one can see here, this is a theoretical life that was transferred in September 2015. And one can see the orange bar, and it says insured life A. So the life is transferred in September. So the bar starts from September, but the entitlement to the fee is for the entire year. So one can see on the second row, the bar is the entire year of 2015. But as Mr. Cottle demonstrates, that doesn't then give them a windfall, because at the back end, 2019, on Mr. Cottle's calculation here, the purple bar runs to September in 2019. So they've recognised the revenue in the prior year, but they're still servicing the life and incurring the costs in the year after. So what we say is essentially that by coming here now and arguing that there should be no ramp down or a 5-month ramp down, what Globemed are trying to do is trying to have their cake and eat it. They've succeeded on the entitlement basis for the purposes of their interest calculation. That increased their interest calculation. Fundamental to that interest calculation was the fact that there was going to be a 12-month ramp down period. And they're coming here now and they are saying that there's no reason why we would have provided those ramp down services. Well, I'm afraid, Your Excellency, that the provision of those ramp down services is inherent in the calculation that Globemed put forward. And it was a positive finding that Your Excellency made when the finding was made on the interest provision. Now, the argument my learned friend runs is to say, well, the contract doesn't require us to do that. Well, as I hope I've demonstrated, that is irrelevant in circumstances where the accounting exercise that has been undertaken was done on the basis that ramp down would be done. But even if the provisions of the contract were relevant, we say that the contract does in fact provide for this. So if one turns to the TPA agreement at paragraph 13.5, which my learned friend took you to earlier at page 393 of the hearing bundle, one can see 13.5 that the effects of this agreement shall remain valid for a run-off period to serve the beneficiaries and healthcare programmes issued prior to effective termination date and until settlement of all pending claims. Now, my learned friend says that that only refers to managing claims, but it doesn't. That refers to managing lives for a run-off period, and the end point is when all pending claims have been dealt with. Now, the reason for that, we say, is a very good reason, because the last thing that will be done is a claim rather than the policy expiring, because you might have a claim that comes in on the last day of the policy, and of course it will take some time to deal with that. So the fact that the run-off period is calculated with reference to claims doesn't mean that there's only an obligation to service claims. The obligation is to service lives for that period. But the last possible date which there could be involvement would be when all of the claims have been dealt with. Now, there is perhaps a bit of confusion here, and I'll give my learned friend the benefit of the doubt on this, that 13.5 refers to a runoff. Now, the experts, when they refer to runoff, refer to something else, which is the period at the end of the ramp down, where there are no lives being managed, and where there are simply the tail end of the services. So that is the claims management that's being provided. So no lives are being managed, but the claims are still being run. And that is agreed to be 6 months. But we say that runoff as it's used in the TPA agreement is broader. It includes the ramp down and the runoff. And that is why runoff in the TPA agreement is a period of 24 months. So it takes into account, it gives essentially your 12 months for your renewals basis for the lives to be managed and another 12 months for you to sort out all of your claims. So, Your Excellency, and I stress, we don't get here, and we don't get here because this point wasn't an issue in trial. It was Globemed's positive case, and there was a positive finding made on the entitlement accruals basis. We don't get here, but if we got here, if we were starting this afresh, if we were in trial and we were making submissions, having heard evidence, having been given the opportunity to cross-examine on this point would still be a dud. So we say that on that basis, it just doesn't get home. So, Your Excellency, those are the two big points, and to some extent, the four residual points flow from ramp up and ramp down, but we say unequivocally and clearly on ramp up and ramp down, our calculation is correct. So I'm turning then to the third issue, which my learned friend called the staffing threshold. This question is, Your Excellency will recall the question of how many lives the existing staff at Globemed could manage. And that matters because, in essence, the more lives which the existing staff could manage, the longer they can delay before hiring staff. And of course, that decreases costs and increases profit. I'm sorry, Your Excellency, I didn't ask if there are any questions on ramp down before I moved on.
No, please go ahead. Yeah.
So it matters in essence because it hits the bottom line, because it impacts the time at which new staff need to be hired, and new staff are obviously a cost. Costs reduce profits. Now, Globemed contends for a figure of 276,000 lives, and we contend for a figure of 205,000 lives. Now, Globemed relies on Mr. Saliba's evidence, and they say that he refers to 276,000 lives. And my learned friend took you to the relevant part of Mr. Saliba's statement where he says that. Now, Mr. Cottle explains that that assumption of 276,000 lives was made before there was other disclosure and before the actual number of lives were known. But my learned friend's main point was that he says, well, we never applied a 205,000 figure. But I'm afraid that that is, again, incorrect. And Globemed's case was clearly that it was a threshold over which new staff had to be hired. Now, that might have been because it was for ease of calculation. That might have been because it was simplification. But that was their case. And that case wasn't challenged. So if that case wasn't challenged, then there's no reason now why they ought to be allowed to make a different case. Now, we can see at page 1036 of the bundle, and this is in Mr. Cottle's second report, the Appendix 3, which is updated loss model. Now, there was a loss model in the first report, and then once the actual figures were known, so that was the new disclosure that was referred to, that I took Your Excellency to earlier, an updated loss model was created by Mr. Cottle. So this was in essence his calculation and the explanation, the numbers behind his calculation. If one turns to page 1049, this is the relevant section for payroll, and this is Appendix 3.4.1. It's quite a big sheet on my screen, so you have to zoom in to the top left-hand corner if Your Excellency has that function. And one can see there, threshold over which additional staff required, number 205,076. So clearly, it was Globemed's calculation that the threshold over which additional staff would need to be hired was 205,000. And that refers to note 3, which is at the bottom of the page. And Mr. Cottle says there, as explained in Appendix 6 to my first report, I have assumed that the increase in lives throughout 2015 would be managed by the 43 staff already employed as at May 2015. I have therefore set a threshold number of lives as being the number of OIC lives at the end of December 2015. And I have assumed that additional staff will, and that should probably say will be required, to service lives over and above this threshold. So contrary to what my learned friend told you in submissions earlier today, that was the basis of Mr. Cottle's calculation. And so again, for the reasons that we've outlined already, it can't be for a party to come post-final judgment and say, oh, well, actually, we'd be rather better off if we'd used a different figure, so please let us use that figure. Of course they shouldn't be allowed to do that. And Mr. Burrows makes it clear in the joint schedule that was produced for this hearing that that position was agreed between the experts. The reference for that is page 1145, and it's behind D8 of the bundle. 1145, Your Excellency. It's internal page 15.
Yes.
And Mr. Burrows, under Mr. Burrows' position at the bottom of the page, it says the experts previously agreed in the joint statement that the threshold over which additional staff required was 205,076 lives. And then he repeats the note there. So this was a point of agreement, and it can't now be undone just because Globemed think they'd be better off if they'd made a different case. So, Your Excellency, that then takes me to the ramp down of staff contracts. This is the fourth issue, and this is the issue of when staff contracts would have been terminated. Now, we say that the finding on this point essentially follows or is an extension of the ramp down argument. And Globemed's primary case on this is that because there would have been no ramp down period at all, the staff could have been terminated immediately at the end of the contract period, and that therefore lowers costs and increases profits. And then they have an alternative case that they would have terminated 31% immediately and then reduced them over that period. Now, we say that if Your Excellency is with my client on ramp down, then we say it's self-evident that the staff termination would also happen over that ramp down period. And that's because these are part of the very costs that Mr. Cottle was referring to when he was describing the accruals recognition basis. These are part of the very costs that would have been incurred in servicing those lives to the end of the 12-month period. Now, we say that that aside, and notwithstanding that it just follows self-evidently from whether there would have been a ramp down period, there was in fact, again, direct evidence on what would have happened to staff specifically rather than costs generally on the ramp down period. And we can see this from Mr. Saliba's witness statement at page 129. We were in this bit before, and this is in the ramp down period. And Mr. Saliba confirms at paragraph 127 that as the OIC lives gradually transferred back from GMGHS to OIC, GMGHS would have gradually adjusted its staff in line with the transfer of lives and requirements based on remaining TPA clients. So in essence, he's confirming what really is obvious, which is that the termination of staff would be done in proportion to the ramp down and the reduction of lives. And that's precisely the calculation that Mr. Burrows has carried out. And so that is the basis on which OIC's calculation has been done. And so that, we say, is the correct calculation. Turning then to ASP hosting fees, this is, again, another fairly short point. There are, as Mr. Montague-Smith trailed earlier, two parts to it. The first part, the bigger part, although not that large in the context of the issues generally, is whether the ASP hosting fees would have been charged during the ramp down period. Now, this again, Your Excellency, depends on whether there would have been a ramp down period. And we say that for reasons we've set out, clearly there would have been. And so clearly, the ASP hosting fees form part of the costs that would have been incurred during the ramp down period. The second question is a much smaller question, which is this point of whether there would have been ASP hosting fees charged during the runoff period. So this is during the period in which no lives are being managed, but which there is the wind down of the operations after the ramp down period. Now, we say that the contract is clear, and the franchise and licensing agreement that Mr. Montague-Smith took you to earlier made it clear that the fees are chargeable at $39,000 per year from 0 lives to 25,000 lives. So there is a cost that's incurred. Now, I hear Mr. Montague-Smith's point on the fact that there would have been non-OIC lives, which meant that that cost might have been incurred in any event. And I see some force in that argument. And so if Your Excellency thinks that there would have been lives in that case, then I can see that there would be an argument to say, well, that cost would be a cost attributable to those non-OIC lives that would have been there in any event and not the OIC lives. So insofar as Your Excellency is content that that's the way to look at it, then I accept that that follows. But I stress the main point on ASP hosting fees is the ramp down period, and that simply follows from whether there is or isn't a ramp down period. That then takes me to the interest calculation period. Now, this is not a particularly complicated point. It is simply saying that in light of what we have set out in this hearing, in light of the fact that Globemed is essentially trying to engineer a higher damages award, having seen the final judgment, by going about face on the case that it ran and about face on the case that was agreed, this hearing has become necessary. And so, given interest as a matter of discretion, if Your Excellency is with me, that what Globemed has attempted to do post-judgment is to amend its assumptions, to inflate its damages figure, contrary to the case that was run at trial, then we say, on the basis that interest is discretionary, that provides a very good reason for the court not to exercise its discretion for interest to be awarded in that period. And it's not a more sophisticated argument than that. And we say simply, if Your Excellency is with me on what we say is opportunistic at best and fairly shameless at worst in the attempt to inflate the damages figure, then we say that simply follows on interest. So, Your Excellency, that then takes me to the seventh point, the last point, which is the question of the non-OIC loss.
Yes.
Now, Your Excellency was taken to the judgment. I think paragraph 101 is the finding in the body of the judgment. That is at page 84 of the bundle.
Yes.
And Your Excellency, this was the conclusion on the question of whether non-OIC loss was recoverable. And the judgment there says, starting from the second sentence, I value GMG's inevitable non-OIC losses at 25% of GMG's total non-OIC claim for each year for the duration of the TPA agreement. Sum of something would usually be between 1 and 49% of it, 0% being none of the thing, and 50% being half. 25% is the midpoint between 1% and 49%. Now, the difference here, and I must stress that the actual result is fairly minimal. Now, I think Mr. Montague-Smith said that we were each potentially batting against our own interests here, because his figure for this loss is slightly lower. My figure is slightly higher. Now, I must confess, I had a similar thought to Mr. Montague-Smith initially, but when one interrogates the underlying calculations, we are in fact batting in the way one would expect in our own interests, because I think what happens is that depending on whether it's OIC or non-OIC loss, that transfers some of the cost between categories. And so I think that the overall loss is slightly, but not very much, lower on my calculation, and slightly, but not very much, higher on Mr. Montague-Smith's calculation. But Mr. Montague-Smith made a first submission, which was he cautioned Your Excellency Excellency to be careful, because I was, to paraphrase, trying to get Your Excellency to make a finding that would help me in my appeal. Now, the wit and cunning that Mr. Montague-Smith has attributed to me is, I'm afraid, misplaced, and one could see that when Mr. Montague-Smith explained the point himself. Because what we are doing is saying, well, what one needs to look at is what 25% of the loss would have been, and that requires you to look at what 25% of the lives would have earned in profit. So I think actually the point is the reverse. I think, Your Excellency, if you find for Mr. Montague-Smith on this, then I think I might have some ammunition in my appeal, but not necessarily if you find for me. But either way, of course, once it gets to appeal, the submissions, or if it gets to appeal, the submissions will be made as they are made. But to be clear, we're not doing this with any ulterior motive. We're doing this because we think that it's the right thing to do. And to explain briefly why we think it's the right thing to do, we say that in essence, the number of lives is the thing that drives the amount of profit. And there are always going to be efficiencies within certain amounts of lives. So if, for instance, and I gave this explanation in my skeleton argument, if a certain configuration of systems or members of staff can manage up to, say, 10,000 lives, then the profits will be greatest in increments of 10,000. So in other words, the profit ratio will drop each time the number of lives just pops over the 10,000 mark, because you then need to change your systems configuration, hire a new member of staff, and you incur the entire cost of that. But then it gradually increases as you move towards the next efficiency spot. And all that we've done is Mr. Burrows has calculated what the profit would have been for 25% of the lives. And we say that that method of calculating is more accurate and it should be preferred. So, Your Excellency, in conclusion, we say that ramp up should be applied as per Globemed's case, as was agreed between the experts at trial, and Globemed should not be allowed to about face now. We say that ramp down should be applied, again, as per Globemed's case, as per the findings in the judgment in relation to the entitlement accounting basis. And again, Globemed should not be allowed to rerun its case now. Third, we say that the capacity of Globemed's existing staff should be calculated on the basis that they could service 205,000 lives. That was the figure agreed between the experts at trial. That was Globemed's own figure. And again, this isn't something which is appropriate in a consequentials hearing to re-argue. We say that the termination of staff contracts follows from ramp down, and according to Globemed's own evidence at trial, should be gradual through the ramp down period. The ASP hosting fees, we say, should be applied during the ramp down period. Your Excellency has my submissions on the runoff period, but I haven't pushed those very hard. Interest, we say, should be calculated to the date of the judgment, so to the 30th of January, because if Your Excellency is with me, that there has been some opportunism here in running the ramp up and ramp down arguments, then certainly Globemed shouldn't be rewarded for that. And we say that the 25% of the non-OIC loss should be calculated on the basis of the profit that would have been generated on 25% of the lives, because, simply put, that is the more accurate way to calculate it. Your Excellency, I wonder if I might just very briefly take some instructions to check that I haven't missed anything that those virtually behind me would want me to say.
Yes.
Your Excellency, I'm told that there aren't any other points that I'm being asked to make. So unless Your Excellency has any questions for me arising out of any of that, those conclude my submissions.
No, thank you very much for that. How long do you need a lunch break? 30 minutes, 1 hour? I'm flexible.
Well, Your Excellency, I mean, my learned friend's got through his submissions even faster than I got through mine. In reply, I've probably got 15 to 20 minutes, if that. So, I mean,
if it is 15, 20 minutes, then we can do it right now.
Well, that's what was my thought.
Yes.
And then we can release you for the afternoon. I can put it like that.
All right. Okay.
I'm grateful.
Sure.
So, Your Excellency, my own friend started with complaints that I was running a different case, and that I was challenging the finality of Your Excellency's judgment.
He says fresh trial.
It's not no. Well, yeah, I mean, exactly. So he says this isn't a continuation of the trial. Of course, it's a continuation of the trial. It's just that there's no new evidence. This is like closing submissions. It's precise. This is not a consequentials hearing. My own friend knows that full well. A consequentials hearing is when you've got the number in the judgment, everything is finalized, save for matters of costs and appeal. This is about determining the quantum, the final amount that my client is entitled to pursuant to this claim. That's not consequentials. That's an essential part of the findings on the substantive claim. It's the quantum phase, if I can put it like that, in arbitration speak. That happens all the time. It's not about consequentials and what happens after judgment. It's about getting to the final number. And Your Excellency's already explained that your existing judgment is not final in relation to quantum. You said that in your reasons about extensions for permission to appeal and so forth. If you need to look at it, it's at page 1728, paragraph 3. But in any event, that's obvious and plainly obvious. This is not a consequentials hearing. It's plainly open to us to make submissions on the legal consequences of the evidence that you heard. It's plainly open to us to make legal submissions at this stage. And I'm slightly baffled by the submission that this isn't part of, or even like, a trial. Of course it is. It's the quantum phase of the proceedings. I don't accept that I'm running a different case in a meaningful way, or in a way that I can't adjust. Your Excellency will have seen this all the time when you have a complex quantum calculation. Of course, there are adjustments along the way. Parties adjust their position in relation to that in the same way that they do when they're running up to the submissions on liability. That doesn't rule out those late adjustments. The question is, what flows from the evidence? Am I right? Not you're not allowed to say that, which is my own friend's immediate response to all of these points. He said, oh, you're not allowed to say that, which is extremely convenient, but not a good way to getting to the right result in my submission. The good way to getting to the right result is to actually consider the points and decide whether they flow from the evidence, whether they're ruled out by the evidence, whether they're ruled out by something that's already been decided. My learned friend points to nothing in the judgments that is inconsistent. Well, apart from there's a new point about this interest calculation somehow carrying with it a finding that affects ramp down. That's brand new. You won't find that anywhere in his skeleton argument because he's come up with it clearly. It's an utterly contrived point, and I'll deal with it. But in any event, you can point to nothing in the pleadings. There's no amendment application that I would need to make to run these points. These are just the sorts of points that arise in a quantum calculation. All he does is point to the evidence. Now, of course, the question is, what does that evidence lead you to? But firstly, all of that evidence is based on a 4-year calculation, not a 3-year calculation. So I can't be held to it in relation to a 3-year calculation. But in any event, the evidence is never the beginning and the end of the question. The experts themselves, and this is again where we fundamentally disagree about the role of an expert witness in these proceedings. The experts are not there to tell you this is how lives would have been transferred back. They're there to calculate the consequences of those findings, of those assumptions. And then it's for me to tell you what I say should be your legal interpretation, the legal implications of that evidence. And in that course, of course, I'm allowed to make the sort of points I'm making, and describe what we're doing as shameless is I'm afraid, wholly unwarranted in these circumstances. Now, in relation to the question of ramp down, my learned friend focused on the evidence of Mr. Cottle. And again, all Mr. Cottle was doing was plugging in assumptions and calculating the consequences of those assumptions. He's not giving evidence of whether those assumptions were correct. And of course, we are entitled to tell you that in calculating the final quantum, you are required or should assume something different. All of those models have changed. Nobody's model is precisely the same as the model they presented at trial. My learned friend's model came to a value, I can't recall exactly what it was, but it was somewhere in the region of $1 million. And now it's 8.5. Everybody's calculations have changed as a result of the changes in the underlying implications. Some of that comes from your judgment, and some of that is left open because your judgment didn't answer every single question that there might be between the parties. Now, what we say about ramp up is, and we can go back to it, but ultimately all we're doing is applying what we understand to be the consequences of your judgment. You were taken to clause 5.4 of the contract, and my learned friend said, well, that shows you that everything was going to happen within a year, and it does show you that everything was agreed to happen within a year. That is at page 1245 of the bundle, and that's clause 5.4. 1245 is the page. Clause 5.4, the parties agree that till the time the existing medical portfolio is transferred to Globemed, which is due upon their renewal as per agreed timeframe, the client shall continue to maintain its contract and services with its existing PBM service providers. And you will recall that so it's on renewal, which is going to take place entirely over the course of a year. And the date of the contract, as we know, is the 13th of January 2015. So it is entirely open to you. It was open to you to make the finding that you did, which we say is very clear, that that everything would be transferred within the year by, I think you said the 16th of January 2015, but in any event, by the middle of January 2016. There's nothing wrong with that assessment. And fundamentally, we say it is already decided. Well, let's go back to it and just look at it very briefly. It's on page 79 of the bundle. Paragraph 85, final sentence. I will attempt to identify a point in time at which it can be said that the transfer certainly would have happened. Yes, in the context of Bupa, but then you go on to cite from Mr. Saliba's evidence in paragraph 86, it's my understanding, in a circumstance where the parties understood the launch date to be such and such, it would be transferred, the complete portfolio would be transferred to GMGHS in the first contractual year, i.e. by 15 January 2016. That's the one that should have been 13 January 2016 because the date was slightly wrong in the statement. But in any event, that was open to you and you made that finding. It's my learned friend who's trying to challenge the finality of that decision by saying, well, actually, hold on a minute, you can't have meant that. You must have meant something different because here are some arguments. Well, none of that is relevant to you. Now, in relation to ramp down, so we've got this new argument, which we haven't seen before, that somehow your findings on interest lead you to the consequence that there must be a ramp down. And there's nothing in that, but I'll come back to that in a minute. But implicit in that argument was that somehow there's a finding in your judgment which requires you to find that the amount, so that the period of providing services has to match effectively the period for which the claimant was getting paid. Now, there is a mismatch because the contract, although it's agreed in January 2015, it doesn't get going or wasn't going to get going until the middle of 2015. But if my friend's right that somehow there's some finding that leads you to the conclusion that the fees have to match the services, well, that's Mr. Cottle's second calculation, which is that it leads to the consequence that you get 3 years fees for 3 years services. That's his secondary calculation. But I'll come back to that in a moment, because ultimately the question of whether services were required to be provided depends on the term of the contract. And we've got yet a new case from my learned friend that actually there was a contractual obligation to provide services during what's called the runoff period. You're supposed to manage lives during the runoff period, which lasts, by the way, 2 years after termination. But we'll come back to that in a moment. So the position, he says, well, actually, this is a change of position, and that there would be Mr. Saliba's evidence was that there would be a ramp down period. Again, all of Mr. Saliba's evidence was focused on a 4-year, not a 3-year contract. My learned friend says, oh, well, that makes no difference whatsoever, just waves it away. But that's a wholly unrealistic submission when the consequence, if you terminate after 3 years, is handing back half of the profit just for free, if that's right. And he says, well, the terms of the contract are irrelevant. But they're not. They're central because they identify what are the obligations of the claimant post termination. Just dealing with this point, though, this new point that that somehow your findings on interest are inconsistent with there being no ramp down. We do say that is utterly contrived. The point about interest was that there was this meritless argument that somehow interest should be calculated on the basis of what was called accruals, on the basis of their case as to when the entitlement to the fees accrued. So they're saying, oh, well, you get paid to some extent in advance, and so on an accounting basis, you'd account for it at a certain point later than when you receive the money. So you only get interest on that basis. And your finding was, no, you get interest on the basis of when the money would have been received. Why? Because interest is always about cash flow. It's got nothing to do with any findings. No findings were made by you about an accruals basis. There are no findings about when those fees were, quotes, earned, and nothing of that sort has been shown to you. All the judgment does is it rules that interest runs when the cash would have been received. And that's just wholly normal. And indeed, the contrary is only discredits really Mr. Burrows' approach, an attempt to sort of wind down interest by some contrived manner. That conclusion doesn't tell you anything about whether or not the claimant was obliged to provide services after termination, and if so, what services. It's about when. It's about saying interest is on cash flow. But as I say, I mean, in my submission, my own friend's case is self-defeating on this because the thrust of it is that the fees have got to match the services, and so the period for which you're getting paid should match the period for which services are provided, which leads you to my secondary case on quantum, which is 3 years matches 3 years. And my own friend then said, oh, well, the contract's irrelevant. It doesn't matter whether the claimant was required to provide these services after termination. But then he says, well, actually, clause 13.5 does require services after termination. So we have to go back to that just to understand what he's saying on this. Page 393, got 13.5.
Yes.
And he says, well, when it says this, the effects of this agreement shall remain valid for a run-off period to serve the beneficiaries and healthcare programs issued prior to effective termination date and until the settlement of all the pending claims. What he says now is that, well, that imposes the obligation to manage lives. But the consequence of that, if you look at the definition of run-off period, you've got to go back to page 381. The run-off period, sorry, I've got to find it myself. So the definition of run-off period is at the bottom of that page, a maximum period of 24 months as of the effective termination of the effects of this agreement, which starts following the end of the 1-year notice period. So if it's right that the whole of so during the, quotes, run-off period, we have to manage lives, that has Globemed managing lives for a whole 2 years, which even my learned friend doesn't make that submission. So the question is, what do we have to do during the run-off period? Answer, run-off claims. And we say that is clear from Article 13.5. That's what we're applying. Those are the services that the claimant's obliged to undertake. And in any event, the experts are agreed that the period of run-off is 6 months. That's an agreement for today. So all that would do would have you effectively, what you're doing is you're saying, I think all he could really say is that for those lives that there are claims, you'd have to somehow manage both the lives and the claims. But then what about claims that come in afterwards? It would make no commercial sense. The point is there's distinct capabilities of the claimant in managing lives on the one hand and managing claims on the other. And that's how the experts have been able to make their calculations on the basis of a 6-month runoff period. So the runoff period is up to 24 months. And in fact, 6 months will be sufficient because you'll get to the end of the claims in those periods. But even if my learned friend was right, therefore, that somehow 13.5 imposed a post-termination obligation to manage lives, it would only be for that runoff period, 6 months. Again, you get to my secondary case on this. But actually, that's not what it's meaning, can't be what it's meaning. It's just saying we've got to provide services to service that runoff. And if I'm right about that, and it comes down to a legal point, is there an obligation or isn't there? If I'm right about that, and there is no legal obligation, and that's what it turns on, then this is a legal point, which of course I'm entitled to raise with you. And if I forgot to raise or didn't raise it today, and you made a decision based on post-termination 1-year management of lives, I could still appeal your judgment on the basis that I want to run a new point of law, which doesn't change anything factually because it's just a legal point. So if I could run that on appeal, of course I can run it today, even if it is, as my learned friend says, a shameless change of case. I'm entitled to make that case. And if I'm right that this does not impose post-termination obligations to manage lives, well then how can you factor into your assessment of loss the cost associated with post-termination management of lives? On staffing threshold, very briefly, my learned friend says my main point, I'm just quoting what his submission was, my main point, he said, was that the claimant, never applied the 205,000 figure. That just mischaracterizes my submissions. The point is that the effect of the compromises that were made in the original model is that that was the threshold that was set. But it was all derived from the evidence, which was 276,000. This is a different model. The fact that you make compromises and changes to make a model easier doesn't fix you for all time with the numerical consequences of that model. This is a different model. You can take the assumptions as they actually are. And ultimately, even if Mr. Cottle had taken that view and had done that, it'd be open to me to say, well, there was an error in that. You can look at the actual evidence, which is Mr. Saliba's evidence, and follow that through into your calculations. The purpose, the purpose of litigation is not to play a game. The purpose of litigation is to get to the right answer. If the right actual answer is 276,000 lives, then that's the number that you should use. On winding down staff and letting staff go, my submission is that it flows from ramp down and ramp down alone. My learned friend said, no, there's another point. If you look at the evidence of Mr. Saliba, he says, well, it would also be run down gradually. But actually what Mr. Saliba is saying there, if you go back to it on page 127, paragraph 129, is that the winding down of staff will follow the transfer back of lives. And so, of course, he's saying, if the lives go back gradually, as one would expect the insurers to require, then the staff will be reduced gradually. But of course, if they go back all in one go, then the staff will be reduced when they can. I won't revisit the issue of ASB hosting fees. It appears my learned friend sees the error of his ways on that. It's not. All I just say is it's not just about whether or not there would be non-OIC lives. It's about whether or not this was a cost which would have been incurred in any event. On his case, it would have been incurred in any event, whether we were performing the contract or not. And therefore, there's no additional cost of providing the services at all, as a matter of logic. On interest, he says, well, it's all discretionary, so you should disallow a certain amount of interest because this is all terribly shameless. It's not shameless because they said 7 million and now they're saying 8.3 million, and it took till 30th of May to get that in an open document. But secondly, interest discretions have to be applied in a principled way, and you don't disallow interest to punish people for taking points. My own friend put it a slightly different way. He said we shouldn't be rewarded for taking these points. We're not being rewarded with interest for taking points. We're being compensated. The claimant's being compensated for not being paid money they should have been paid, for not being paid money that Your Excellency has found that the claimant is entitled to. And that's the basis for calculating interest and applying it. And so there's simply no principal basis to say, well, I don't much like your points, and therefore I'm going to disallow interest. There'd be a wholly unprincipled approach to the application of interest. And in any event, as I say, we don't accept that they're right about all of these points. And we certainly don't accept that these points are shameless or somehow is terribly egregious that we should be making them. Your Excellency, that was 20 minutes, and that's all I had to say, unless you've got any questions for me.
No, thank you. Look, I should admit that case wasn't an easy case. It was very complicated. It was a 5 days trial with a lot of experts and very, complicated when it's come to the technical point. And I hope my judgment was not complicating the issue. I hope my judgment was, try to solve the problem. And I hope the approach I took by, leaving out the quantum later on, it's acceptable approach. Let me see what I can do with come out with a judgment on the quantum. And we have to prepare as well for the appeal in the 2 or 3 weeks time, I guess. If I'm not mistaken.
Is it 4 weeks?
I cannot recall which date. Is in July, right? It should
I
be
think so, yeah. I think it's 4 weeks from now, Your Excellency.
4 weeks from now. That will help you to come up with my decision on quantum before the appeal, or it will complicate the issue if I get it after the appeal hearing. I'm trying to do my best before the summer.
We're in Your Excellency's hands. The only thing I would say is that obviously there's no overarching need for Your Excellency to deal with permission to appeal in a hearing, but there may be points which arise out of a quantum decision on these 7 issues, which one or other party might want to challenge on appeal. If it was possible to have a little bit of a gap. I mean, ordinarily, when in the English approach, what you'd do is you'd issue your judgment in draft, and then we'd argue permission to appeal in front of the first instance judge at the consequentials hearing. So we'd only need a few days' notice, really, to be able to ask for your views on whether there's a real prospect of an appeal. And then if we disagree, we can take it on and upwards. It would be helpful, I suppose. But I'm very mindful of Your Excellency's timetable. The other thing is, depending on where you get to on these 7 issues, you might want further calculations. And so it may well be that you want to come back to the parties and say, I want a calculation based on if I was to decide the issues in the following ways, what would the number be? Can the parties agree that? And you will need an updated calculation of interest from me anyway, because if I'm right and we should continue to get interest, it should run to the date of the actual quantum judgment. So there may be a little bit of back and forth on that, which may make it impractical. But obviously, anything you can do to help us would be much appreciated.
Yeah, Mr. Kalan, any comments?
Your Excellency, only that I endorse Mr. Montague-Smith's comments, which is we're very aware of how precious Your Excellency's time is. If it were possible to have a judgment, say a week or 2 weeks before the appeal hearing, then that might allow us to deal with everything in the permission to appeal hearing, which would, of course, if that's incentive, Your Excellency, save Your Excellency from yet another outing with Mr. Montague-Smith and I. But there's nothing that means it has to be done that way, although it may be slightly more efficient and slightly quicker.
Yeah. So, Mr. Kalan, are you going to appeal before me for the permission to appeal, or Robert Reed?
I believe it's me, Your Excellency. It's certainly in my diary.
Sure. Excellent. All right, then thank you very much for making my timetable for today shorter than usual. I just need to take a break for today as well. Yes, I spent very busy night last night because my daughter graduation was last night, so it was a tough night.
Congratulations.
Thank you. Appreciate it. So thank you very much for your time. You will hear from me as soon as possible. Appreciate it.
Thank you.
Thank you.
Thank you.
Bye bye.